On the basis of the application of the IO, the magistrate has recalled his own order, my lord, bypassing the restrictions imposed under section 362, my lord. The magistrate has directed the petitioner to produce the vehicle.
You are challenging that order.
That order, my lord.
The first order which was passed.
Passed in my favor. The other side, the other private opposite party's application under section 457 was rejected, my lord, confirmed in revision, and that is before your lordship for consideration.
When that matter is coming?
That order was, that matter was in the year 2023, my lord.
When that matter is coming up?
My lord, he has directed, already appear, but I do not remember the exact date.
May I and give me the date so that we will tag both the matters.
May I pray this matter to be taken up after recess, because 12 तारिख दिन से कहै produce जदि न करियो पुलिस नै जिवो.
No, after it is not possible.
12 तारिख दिन नै जिवो, रविवार 12 तारिख पडुछि. Unless
what is this property?
Property is a JCB machine, madam.
Oh, then I can't bring it back if it takes.
Yes, that is the whole difficulty.
I can't go. I can get it back by a direction.
Your lordship, then, but it is again very difficult to.
No. Once he takes it, then I'll take it. The right course. Don't worry. Take it.
Pardon, my lord.
Monday, your lordship.
Pardon, my lord. Application under section 311 has been rejected, my lord. Now the evidences from the side of the prosecution has already been
closed. When the witness was examined?
In the month of December, my lord.
The witness you are seeking recall, he has been examined when? December?
December.
Oh, take it.
Your lordship directed to list this matter today, but that has not been listed. Your lordship will list this matter on Monday.
15.
Monday, my lord.
15. Yes.
Pardon to mention, my lord.
I may be pardon, my lord. The restoration matter of old matter.
What is the urgency?
CMPL.
What is the urgency? It will come.
Essentially, because my lord, in dismissal of the writ application.
When have you filed that CMP?
CMPL, my lord. 2024, my lord. That is not.
When the matter was dismissed?
Notice was issued.
When the matter was dismissed?
17, my lord.
17 today. It's so urgent.
Well,
overnight.
But after receiving notice of CMPL, they have now initiated to evict us, my lord. Because the petitioners all scheduled caste persons.
Give it. Yes.
Pardon to mention,
next week I did it, my lord.
We'll see. How can
my lord, unless I have not stored. Because of
all right,
next week any day, man.
Give eviction. Take
Pardon.
Because eviction, I'll take it.
Yes, my lord.
Pardon to mention, my lord. There is a case under section 457 release of vehicle, my lord. The matter is 223, my lord.
What do you want?
The release of the vehicle, my lord. But the matter not listed.
Where is the memo? You give the memo. You see, the release of vehicle is not so important. Yes.
Obligement.
Any mention from item 1 to 8?
My lord, item 2. On behalf of Dr. Mahabhadra, kindly adjourn for 1 week.
Urgent.
My lord,
after 1 week.
My lord, item 3, 5, and 6 and 45. On behalf of my learned son, his father-in-law has expired, so kindly take it up to 3, 5, 6, and 45.
The counsel for the petitioner submits that there is a bereavement in the family. When she will seek the family of the lawyers, family of the counsel appearing for the petitioner.
My lord,
for the petitioner.
3, 5, 6, and 45.
Sorry. Yes.
Obligement.
Item 8, my lord, on behalf of Mr. Chan, my lord, I prefer 2 weeks time, my lord. Mr. Chan is not here today.
My interim order is there? No, urgent. April, yeah? Yes. Mr. Chan, on behalf of Mr. Chan, a request is made for it. Yes.
Item 7 withdraw.
Withdraw item 7. Yes.
Item 9 to 17.
Item 10, my lord.
Item 10. There is no pay order, kind of no chapter.
Sorry?
There is no pay order, kind of no chapter, my lord.
Compromise matter. You have taken stay.
No stay there.
Okay. On request, urgent.
Item 9.
9 years. Not 1 week. It will go to first week of April.
Item 18, you lordship.
First week of April. Whoever is asking adjournment, put it first week.
Item 11 and 12.
11?
11 and 12, my lord.
Urgent.
Adjournment. I prefer.
So, first week, second week of April.
Item 15, Your Lordship.
Wherever interim order is there, just take it. 15, yes.
Your Lordship, I am appearing for the informant, Your Lordship. Today I am filing my VNMI, Your Lordship.
Let it come.
I am for the petitioner, my lord.
You are for petition. Okay.
I will solve the copy, my lord.
So-and-so entered appearance for opposite party and seeks an adjournment for filing the response. Release the matter. After. Yes. March. Yes.
Okay.
Yes.
Item 18 to 26. Item 54. Man.
Yes.
Taken up 2 weeks.
For whom?
Well, item 2.
You are for whom? Petitioner.
Petitioner.
Okay. Adjourn it. April 2nd week. Yes.
Item 27 to 37. 38 to 40. 41 to 44. 46 to 52.
40? Yes.
53 to 58. 59 to 67.
Item number 59. 2 weeks time kindly on behalf of S. Mishra. His father-in-law died.
Whose father-in-law?
S. Mishra. On behalf of S. Mishra.
Okay. There is learned counsel on behalf of Mr. Sangram Mishra advocate. It is stated that there is a bereavement in the family. Hence, seeking
The interim order.
ordered though. Okay. Yes.
68 to 70.
Lordship, item 50.
Hmm?
Item 50, I'm praying for a short action.
50.
Yes,
50. So, huh?
Notice sufficient.
Notice sufficient.
Nobody appeared.
So wait. Other side may appear, na?
Yes, sir.
Yes. No, nothing.
Item 1.
Wait, please, my lord. This is against the rejection of an application under section 205 of CRPC.
Yes.
For dispensing with the personal attendance of the accused. The petitioner who is accused of the offense under section 3 of the PMLA is being prosecuted in the court and he is critically ill and is a resident of Jharkhand, so it is not possible on his part to
Where is
attend the
that?
court.
Where is his illness proof?
Illness, the medical certificates have been filed and the current medical certificates also.
Show me.
I am filing today. Let me, one thing, Lordship. This case, the scheduled offense is under section 13(1)(e) of the Prevention of Corruption Act.
I need not go into all this.
Lordship,
If you
one
have a
minute.
health problem, then we will see. You have health problem. You have placed it on record before trial court.
Yes,
Why
yes.
is it there?
Why I am
Where is
submitting
that
Lordship?
judgment? That judgment, 205 judgment, Supreme Court judgment.
To the order of the learned trial court,
No, there is a judgment of Supreme Court.
this court.
Supreme Court, there is a judgment. Where is that judgment?
I have not brought the
I just
judgment.
pass you over, there is a judgment.
Lordship, one thing, just
PMLA case, yes.
1 minute, just
Yes.
Lordship. What has happened, Lordship, the scheduled offense and this offense are both tagged together.
Yes.
In the scheduled offense, his application under 205 has already been allowed by.
So
the
where is that order?
I am filing that order.
You get that order, I am passing it over
Lordship may adjourn it for a period of 1 week.
Okay.
I will file the certificate.
next week.
Next week.
And get a judgment that PMLA case, there is a Supreme Court judgment.
Yes, Lord.
Para, I think, para
Yes.
23 or something.
Yes.
Item 4.
File this application challenging the order of cognizance, Lord, on the ground that, my Lord, the dispute between the parties appears civil in
Yes, Mr.
nature.
Agrawal, you have any problem?
No, I don't have any
Eh?
problem. Actually, that is an, I think my senior will agree It's a prior to Tarsamla judgment, rejection of 205.
Therefore, I'm saying, see, where is that judgment? That's what I was telling.
Just give your document, I just.
I'll allow that. Let him move a fresh application. See, now the regime has changed.
Yes,
My
yes.
senior knows, my lord.
Leave that the citation.
I'll just give, I'll
Yes,
just give.
if
I'll allow it.
if your lordship will grant the liberty, I will move again.
That's what I'm saying. I
Yes,
got that.
yes.
Or he can,
In view of that
you
judgment.
know, what has happened, that man is not well, I agree. Though I cannot officially say, he can appear, your lordship will direct him, he can appear through video conference.
Yes, that same thing I'm going to do. You give me that order.
I'm
I'll pass.
just giving.
Okay, I'll pass the order.
No, sir, I-
I'll pass the order. Huh?
Yes, sir.
Give that, please give that.
I'm just now giving, within a minute I'll give.
And yes, you were telling that predicating office, where is that place?
19/9, he knows.
where is that?
19/9, 2024.
We have that order with you.
19/9, 2024 is the order in TR case number 12 of 20,
Okay,
2020.
I'm just giving a draft.
Lordship.
Petition is agreed by the order dated 10/7/2023, whereby passed by Learned Special Judge Special Court PMLA Bhubaneswar in criminal miss case bracket PMLA 39 of 2021. Whereby his application under section 205 CRPC has been rejected. Mr. Moon, Learned Counsel for the petitioner, submits that the predicating offense and the PMLA proceeding has been tagged together and
tried in
the trial is simultaneously going on. Insofar as the predicating offense is concerned, his application under section 205 CRPC
has
has already been
allowed
allowed.
by the learned trial court by its order dated 19/9, 2024.
Don't show. And he also relied upon the judgment of the Honorable Supreme Court in so and so, so and so. Like that, so and so. Mr. Agarwal will give so and so. He seeks permission to liberty to withdraw the present petition to move a fresh application before the trial court. If such application is moved under section 205 CRPC, the same shall be considered in the light of the judgment of the Honorable Supreme Court, Honorable Supreme Court. And
That is, my lord, in criminal appeal number 2608 of 2024. 2608 of 2024, Tarsamlal versus Directorate of Enforcement.
Tarsamlal versus Director of
Enforcement, my lord.
ठीक है
Oblige.
allowed. Yes. Yes.
The
Yes, sir.
challenging the
Sorry.
order of cognizance, Lord. On the ground, Lord, the matter is purely civil in nature, and the informant give a color in criminal nature allows this FIR, Lord.
Yes.
Your Lordship kind of grants the 161 statement of the
What are the allegation?
allegation, my lord. The offense under section 323, 294, 354, 506, and 34, my lord.
Show me the charge sheet.
Yes, Lord. I have filed the charge sheet, Lord.
Where is that? Charge sheet. Have you filed the charge sheet?
Yes, Lord. I have already
Okay,
filed.
fine. Yes, yes, that's it.
The police already completed the investigation, Lord. In the
Let us see the
investigation,
allegation. During the course of investigation, report we to the person's name. I'll issue notice. This is a very small fight.
Yes, Lord.
Yes. Issue notice. He accept notice for the state. Opposite party notice.
Lordship, I file on IM, Lord.
You move application for them. Yes. File the process. A very small dispute.
Yes, Lord.
We can sort it out here. Yes.
13.
1-3. Yes. 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 What is this matter? Whose petition is this? City Con Engineer Union of India. Nobody is there. Pass over.
It may be taken up next week.
Let us see how urgent. You have any problem? Today?
I have and court number 1, I have a lot of cases to do.
Okay. Mr. Agarwal appearing for respondent. Respondent Union of India is preoccupied, hence he seeks an adjournment. Release the matter after 1 week. Yes. Non-appears for the petitioner. Yes. Yes.
Item 14, my lord, page 8.
Mr. Kedia, Agarwal is there. No, Mr. Kedia, it's Agarwal has written. Yes. Yes. 14.
My lord, he is mentioned that batteries name become settled in page 8, paragraph number 2.
Nobody is there.
Pass
Pass.
Steel.
Matter lordship arising out of a 113 NI Act matter lordship. Last the lordship directed to file and petition for recall. That petition has not been annexed in the criminal miscase petition lordship.
Mr. Mansingh, Interim Counsel, petition seeks an adjournment to file additional document to substantiate the case.
Only impugned letter is filed.
Adjournment.
Adjournment.
Mr. Mansingh was asking for adjournment. That's what he says. Let him come. Yes. Pass over. Yes.
17.
17 lordship.
My lord, could kindly pass over this matter.
Pass over?
Yes.
17?
Yes.
Okay.
18.
18 lordship is seeking for quashment of affair. Victim at the age of the occurrence is 14 years lordship. And now that there is a marriage has been took place between the victim girl and the alleged boy lordship.
POCSO is there.
But only affair has been filed, nothing more is filed in this brief lordship. Only affair copy lordship. It's not certain whether that's been filed or not. The affair is of the year 2021.
19.
Please no. This is the matter, my lord, where your lordship covered by your lordship. If this arises of same FIR, same everything. My learned friend has also given it the last occasion. Yeah, the earlier order was of coordinate bench, which your lordship had followed, adopted, my lords. That order your lordship finds at page 102. This order your lordship had adopted. Further, it is directed at learned court in session over the matter shall consider bail application petition by keeping the view the aforesaid observation. Further, is directed at the petition is released on bail.
So the coordinate bench granted the bail. Considered the application of the petition Pradeep Jana, who was also an absconder. Here, present petitioner is also an absconder.
And your lordship has also considered.
Yes, sir, that particular lordship on Pradeep Jana, who is similar to person absconder, that is the page order in the order your lordship's order.
Lordship order is 2312.
Paragraph?
6 your lordship.
Yes.
Put amount.
Pradeep Jana and who is similarly Pradeep Jana was also absconding.
Yes, Lord. Present was an absconder.
He is covered by Pradeep Jana and Botua Jana.
Same. Both the matters are same. Both the matters are same. This and the other one is also the same.
Same order. Okay, same order.
Para 8 same day consider.
Both the courts will consider the.
Okay, same order as it is.
Same, exactly same.
19 to the matter, same order.
Great. The
case of the petitioner is the petitioner is similarly situated. The co-accused Pradeep Jana and petitioner is similarly situated like the co-accused Pradeep Jana and Botua Jana, alias Gyanaranjan Jana. in both the cases, the court has already granted the following relief. Para 8, following relief. The petitioner is seeking the similar relief. Regard being had to the order dated 19/9/2024 passed by the Court bench in CRLMC 3307/2024 and order dated 23/12/2024 passed by this court in criminal MC number 4728/2024. The present petition deserves merit, and accordingly the following order is passed.
One addition, Manoj. For courts below in paragraph 8, courts below on the same day, learned courts below on the same day.
Courts below,
courts below
on the same
day.
Same day.
Say patta, be the word.
On the same day.
On the same day.
Consider the bail application by the courts below on the
same day.
On the same.
Courts below on the same day. Great.
Plural likho, courts.
Courts. This other one is also the same. Pintu Jana is also second.
Both the matters.
Two separate orders.
Yes. Separate order.
Again, copy of your lordship.
Yes.
Item 17 will.
17 what happened?
17 just passage. After.
What do you want?
I want to do the case. Business matter matter. Passing of proceeding. The present petitioners are purchasers and sellers. It was alleged that the district sub-registrar was undervalued the market. That is the duty of the district sub-registrar and the other officers. The petitioners are no way connected to the case. Last time I have served copy and another copy served on Mr. Mahana, and also the FIR charge sheet and all the police papers I have also given.
What are the allegation against you?
Only 120B criminal conspiracy, my lord. Page 21, my lord, of the brief.
13-2, 13-1B, everything is there, 120B.
And I mean, pardon, we are not government servant. 13-2 against co-accused persons. Against only we have abated the offense.
Yeah.
My lord, kindly have a glance to page 21.
Where is the charge sheet from? Show me the charge sheet.
Charge sheet copy last time I have filed. My lord.
Yes.
I was handing over my lord told the
It is there.
charge sheet is there.
What are the allegations against you people?
My lord, page 53.
53.
My lord. My lord, towards bottom, my lord.
Yes.
In sale deed number so and so, it was found that the documents had not been processed through valuation clerk and head clerk. So that means against the co-accused persons, not against me. It contains the signatures of DSRC Kumbar only. There is also no checklist in respect of those solely. It reveals that no adjutants had contacted the Bhattakrishna Sahu retired peon.
Who are the beneficiary? Who are the beneficiary of this?
It is alleged that undervaluation was done.
Beneficiaries are you.
I'm beneficiary.
That is why 120. Simple as that. So simple.
That is
the officers will do like this only. मुझे लेने के लिए. To give you benefit.
But there is other procedure.
To give you benefit, everything has been done. And therefore the officers are in soup. Today you are saying that I am innocent.
I am innocent.
You got the work done through the officers by undervaluing the documents.
No, we have not done. And that is also in the...
Rather, the contrary, the officers are innocent. You made them to work. Let the officer come, I will consider their case. You face 120B, it is you who has instigated the officers to get undervalue document to derive
under the Registration Act.
Don't go by the registration. I am not deciding the case finally.
There is also
Cognizance Order.
There is also other procedure, my lord. If there is undervaluation, the officer has to give notice to the vendor or vendi, they will deposit. Or other proceeding,
that will eventually follow.
But no criminal offense is made out.
No.
I will show some decisions regarding registration of the document. No criminal liability.
Mr. Ponda, Milords, he was groomed
in a particular chamber where PC Act is the only provisions where he is a product of that. chamber.
Might be under his advice it has been done.
And the possibility of sharing the boot is why his clients cannot rule out notes.
That's there. See, the undervaluation and all that the stamp act will take care of. The stamp collector, he evaluate and all this because is lost to the exchequer. But your role in manipulating things.
No. There is not a single word.
We see the charge sheet. See the charge sheet. It's very exhaustive charge sheet. Very, very exhaustive charge sheet. Every detail is considered by the police.
But every detail.
I think you argue at the stage of charge.
Man, I pray.
Give that liberty, you argue. You may have a case for discharge. And another problem is, you have made so many petitioners whose role is what I don't know. I can't check it.
Only purchasers and the
better would be to argue at the stage of charge.
I consider with my lord. I am preparing a small date chart. Who is at the purchasers? Who are the sellers?
So prepare the date chart, give it to the trial court at the stage of premise of charge, argue it. I will not do it. Cognizance is rightly taken.
Cognizance for the 120 criminal conspiracy, meeting of minds.
You are saying 120B is not made out. Who will decide it? Charge court will decide it.
But the absolutely only allegation against the officers have done this. Let it come and go. I am preparing a short one.
I am giving you that liberty. Go and argue. You move a specific application to that extent, I'll write. Specific application for discharge will be moved by you. The same shall be considered individually. Individually. You have made all of them the petitioner. Better you file individually. Individually, it should be dealt with by the time. I'll write that.
Individually, no offense is made out. My lord, one thing I pray, my lord.
Yes.
Subject to my lord,
Yes.
My submission, look at no offense is made out, and the officers are responsible. Who have no responsible, and if there is anything done, then the authorities should have proceeded under section Stamp Act and Registration Act, not under PC Act.
No, not PC Act. 125 is staring at us, sir.
No.
Petitioners are agreed by the order dated 26/7/2024, passed by Lieutenant Special Judge Vigilant Sambalpur in the CTR case number 17/49 of 2024, whereby the cognizance of offences punishable under section 13(2), read with section 13(1)D PC Act 1988 and section 120B IPC has been taken against the petitioner. Mr. Pandal and counsel for the petitioner submits that all the petitioners are private parties. Therefore, the offence under Prevention of Corruption Act doesn't attract. However, under the aid of 120B, the petitioners are being subjected to prosecution. He further submits that the case, even if the entire case of the prosecution is accepted at its face value, the only offence or the only facts emanating from the record is that the petitioners have undervalued the document which is registered. Co-accused persons have undervalued registered the document which are undervalued. For that, under the Stamp Act, a different procedure is given. Hence, there is no mens area involved in the present. Mens area involved in the present. I am not inclined to entertain the present petition at the stage of cognizance. However, liberty is granted to the petitioner to move separate application. Individually, separate application individually before the trial court for discharge, seeking discharge. If such application is moved, the liberty is also, it is open to the petitioner to take all the points as has been taken in the present petition. The trial court, it is expected that the trial court shall deal with the issue individually and pass appropriate order with this.
And another thing, my lord, the petition has not been named in the FIR. Only FIR was against ex-DSR. That and civil liability, no criminal liability. That line may add.
Why should I see? Then I'm prejudicing.
That observation will help us.
All the points I have to. Yes.
And civil liability खाली गोटे line लिखी देंगे.
He also submit that the liability.
Unless civil in nature, no criminal
Civil
liability.
in nature, no criminality. Mention is not that. That's what I'm saying.
I say what
Criminal
like
liability can be faster on the basis of the allegation made by the vigilance part in the charge sheet.
so blessed.
Yes.
Lordships, in item number 20, this is an application for the quashing of the FIR which was registered by the Jagatpur police station.
Yes.
On the previous occasion when this matter came up, your lordships directed me to approach the lower court, approach the learned trial court for filing a compounding application because the offences alleged were under section 406, 409. However, lordship, section 409 of the IPC, it is a non-compoundable offence. And lordship, my
I have not said anything last
no,
occasion.
Lord, it was an oral. It was a simple adjournment to today's date.
You said all compounding offences. I said go and file.
No, lordship. It was a mistake on my. It was a mistake on my part, your lordship. Lordship, the reason I am before your lordship for quashing the instant FIR is because the case is with relation to non-payment of EPF dues. Since there is non-payment of EPF dues, the company which was held liable for that, since the allegation, it has gone into resolution and it has been acquired by a successful resolution applicant under the provisions of the Insolvency and Bankruptcy Code. And your lordship, the Honorable Supreme Court, in the case of Ghanshyam Mishra, they have clearly stated that. Yes, your lordship.
Before going the merits of the case, your lordship, here is the FIR is 2014, your lordship. Admittedly, 2020 is charged as filed by showing the accused absconder. Thereafter, the petition approached before this honorable court and forced 82 application for seeking questioning of the imbue also. This honorable bench is directed to surrender and by giving an interpretation to move for a remedy.
No, what is the now the company has been.
Yes. Thereafter, present petitioner without maintaining that order granted by this honorable court, approach under section 438 before this honorable court in advance is granted bail. My response submission if the petitioner is exercising 482 judicial of the honorable court, come with clean hands.
He is not.
Lordship, that all of that has been stated in my petition. All of that.
Let us see the judgment. Thereafter, he'll go and wash his hands and come.
Yes, sir.
Okay. Let us. Okay. Which para?
Lordship may come to.
Only show me the RS liability. Where
Lordship, page number 60 of my memo. Page number.
Show me the paragraph, relevant paragraph.
Paragraph number 102 at page number 60.
102.
Yes, your lordship, at page number 60.
Yes.
Page number 60, paragraph 102. Conclusion portion on the bottom, middle and bottom portion of the page, your lordship.
102.
102. 102 that it has been stated at 102.1.
102 is para.
Page 60.
Yes. Result.
Conclusion, your lordship.
Once the resolution plan
is duly approved by the adjudicating authority under subsection 1 of section 31, the claims as provided in the resolution's plan stand frozen and will be binding on the corporate debtor. Its employees, members, creditors, including the central government, any state government or any local authority, guarantors or other stakeholders, on the date of the approval of the resolution plan by the adjudicating authority, all such claims which are not a part of the resolution plan shall stand extinguished.
Then you have to show me whether
and the resolution plan.
The resolution
plan also I have annexed.
Show me the resolution.
Yes, your lordship.
It's not included.
It has been included. Point number 12, your lordship. If your lordship would.
Where is the plan?
At annexure number 8, your lordship.
8.
Annexure number 8, page number 105 is the point number 12, your lordship.
Yes, where is that?
Page 105.
105.
5.
105. Yes. Where is that?
I just
non-payment of the stamp duty to certain instrument. No action can be taken.
Lordship, I apologize, your lordship. Point number 30 at page 118. I apologize.
118.
118.
Yes.
Point number 30 begins at page 118.
118, yes.
Point number 30 it states that directions from the adjudicating authority that other than actions taken by the COC/resolution professional against the personal
118.
guarantee.
30.
Point 30, page 118, Annex A.
Where is that
Your Lordship,
claim?
it starts at point number 30, and the operative portion of
These are the general statement made in all resolution plan.
Lordship,
If you have not seen the resolution plan.
Lordship, the operative portion is at point number B.
You show me the amount in the FIR and show me the resolution plan.
Resolution plan is, Your Lordship, at Annex A.
These are the general statement.
There-
All comment dues and all these
There
are
has
the
been a
general statement made in all the resolution plan.
Page number 120, it has been stated that all criminal matters shall stand quashed. Page 119 and page 120. Point number 30, page 118, the point starts. 119 and 120, point C. Those related to taxation. Point B of page 119, the last portion. Those related to taxation, related to the environment and forest laws, railway claim, disputes proceeding under foreign exchange management, Prevention of Money Laundering Act, and criminal matters, etc.
Where are you reading? 30.
30, point B.
Suit
Page-
proceeding, certificate proceeding. Was
Point B
also incorporated.
Page 119, point B.
119,
9,
yes.
point B.
Recovery of any dues.
Recovery of any, second point. Point
Statutory
B.
dues.
Those related, yes, Your Lordship,
Also.
those related to taxation. And at the bottom.
Yes,
port-
what do you say?
Lordship, that affair of the 2013, Your Lordship, for the period, Your Lordship, 3/12 March 2022, 12 to 3 March 2013, Your Lordship. At that point of time, the present
This resolution plan is
company
accepted?
Lordship,
Resolution plan is accepted?
resolution plan is accepted. The new successful resolution applicant has taken up the
Taken over.
operations. In fact, Your Lordship, I'm sorry.
Issue notice, I'll issue notice and stay.
and the
Because this is the case.
15 lakhs 14,533 they are outstanding, lot deposited before Lordship.
Whatever, but
Yes,
the
sir.
resolution plan is a part of resolution plan. And resolution plan is accepted. The RA is taken over.
But
And
that-
is a corporate, the RA, the section 7 proceeding was initiated by the corporate debtor.
that-
What to do?
Lordship, then
You should have claimed there. Generally, nobody claims. That's the problem, comment dues.
One last submission, if I may be allowed to make,
Right.
Your Lordship.
The learned counsel for the petitioner taking me to the no, petitioner is seeking passing up for the entire criminal prosecution initiated by the opposite party for alleged offences punishable under section. What are the
406, 409.
406 so and so so and so. Okay. 406 and 409.
Yes, sir.
409 IPC. Learned counsel for the petitioner submits that the petitioner is the director.
Petitioner is the director and the erstwhile director and erstwhile promoter.
Petitioner is the promoter director. Huh?
Lordship, erstwhile promoter.
Petitioner is
director.
the promoter director of Messrs.
Messrs. Cosboard Industries Private Limited.
Jagatpur Industries. What is the company name?
Messrs. Cosboard Industries Private Limited, having its registered office at Jagatpur Phase 2.
Cosboard Industries
Private Limited.
Huh? Private Limited or Limited?
Private Limited.
You have written Limited. Industries Limited.
Sorry. Cosboard, I apologize. Cosboard Industries Limited. I apologize.
Cosboard Industries Limited. He submits that the company, namely Cosboard Industries Limited, suffer the resolution proceeding, and the resolution plan submitted by the RA has been approved by the NCLT. Which NCLT?
NCLT Cuttack Bench, Your Lordship, and the
NCLT.
approval order is on 3/2/2022.
By the order dated 16/3.
No, 3/2/2022.
3/2/2022.
Annex A.
He has read out the resolution plan extensively. The relevant part of the resolution plan 119 paragraph 119.
Paragraph 30 point B.
30.8
B.
A and B.
Yes.
118 and 119. Okay. On the basis of the aforementioned resolution plans, the petitioner says that the present petitioner being the former director of the company is absolved from all the liabilities, all the liabilities. Issue notice to opposite party number so. In the meantime, proceeding before so state. Yes.
Lordship, may I pray for an urgent certified copy of the order?
Let it come. Yes, next.
31. Oblige, your Lordship. Much obliged.
Yes, sir.
The last occasion, I was pleased to, while hearing, directed me to give the 313 statement. That case where my defense application for to examine some defense witnesses
struck down.
Was struck down. Exactly, madam.
Where is 300?
No question has been put with regards to that information, classified information. My lord, though, my lord, I had given a chart of 17 witnesses, my lord.
No, the last question 21, question number 21.
My lord, with regards to that is with regards to case re kon kaya
what is your defense then?
My lord, I have been
trying to establish that defense.
I have been I have been falsely implicated because this classified information is such a thing. Unless it will be put to me, that question has been put to IO specifically. He said, I do not know what is classified information. My lord, for that reason, my lord, one thing that this is a right which comes to the accused. Accused should not be. I would have examined myself. The present petitioner would have been examining himself as defense witness. But it is
313 you can 315.
It is better, my lord, because no time I have taken. Very fast date I have filed this application.
But the right, what are you seeking?
Only I want that. My lord, may see page 49.
49, yes.
The 17 witnesses I have categorized. I want to examine only 4, 7, and 14. Those who are 4, 7, and 14. They are the persons, those who are working in Chandipur itself, which is around 15 kilometers from Balesar. They can be summoned in one day and can be examined. They will clarify whether this information which has been recovered from my phone is classified information or not, because they are technical experts. Not that
whether it is classified information or not. Why should anybody will say that is
that they can, because that is my own.
It has to be
only defense.
Unless for the purpose of classified information, it needs a declaration.
My lord may see by the deposition of PW9.
No, suppose you bring a witness.
Will not
this
come.
Particular information is classified.
My lord,
will it be classified?
My lord,
suppose you bring in witness. You ask him that whether this information is classified or not. He says that yes. Will it be classified then? Classification for that.
That may see Dr. B. Sucharita, Associate Director, ITR, Jadipur. He is an expert of this. She is an expert.
Expert of what?
Expert, but with regards to this ITR affairs, that which information should be concentrated there itself in the office. We should not go outside. Whether this sort of things will hamper the test range or not. Deepak Kumar Patra is also by the technical officer.
You file the questionnaires then. You file the questionnaires. Because they are official witnesses. I can't afford to call everybody
only
and
one question
subject them to.
Yeah, I will. My lord may direct that.
You file the questionnaires here.
Here?
Yes. Confining to 3 witnesses, as you said.
4, 7, and 14.
Right.
I obtained this information from the council.
Because the problem is not that. I can understand if you move an application under 315, examine yourself. Thereafter bring them. I can understand that. In 313, you don't say anything. You don't examine yourself as a witness. You want an official witness to be summoned for defense.
I cannot say, because when I am repeatedly putting questions to the witnesses as well as the investigating officer, that the information which has been taken from my phone, that is not classified information, but I remained silent. For that reason, I say 4, 7, and 14. That struck to my mind, my lord. If I will call for a witness from Bangalore, it would take time. So
No, that's fair enough. That's fair enough.
I instructed.
But where have you said that these
I
are not
instructed
classified
the
information?
local council to concentrate somebody who can give this information from local office. So on instruction, I am submitting 4, 7 and 14. They are from Chandipur, there which is 15 kilometers highway. No bata will be necessary for them. Or my lord, if I will deposit 500 rupees, they can come in a taxi and deposit the same. Nothing, my lord. No adjournment will be required for that.
No, those things are not. I'm just wondering one thing.
Because it's a case on special act.
In which
It's a case on special act because official secretion, my lord, may say 3, 4, 5.
Therefore, I'm very careful.
Accepting the entire case of prosecution.
As
it is a case of 120A and 120B is not made out. But 3, 4, 5, whether it comes under official.
These are the cases where national security is involved.
Yes, my lord. For that,
We have to be very, very careful.
I am conscious, man. I am conscious.
In your 313, you have not said a single word that the information are not classified information.
If my lord so desires, my lord, I can file it by Monday or Tuesday.
You file a question, let me examine, because see, we can't.
Yes.
I'll just record it. Record it.
In the learned track is clearly mentioned that Defense Counsel has taken sufficient adjournment and recall the PW9.
See, and don't oppose an application in a so casual manner. These are we are going beyond what you are saying. Short time, all this is not important. Important is he is being prosecuted for serious offences. He has a right to defend. In the same time, you have to balance the act. He can't call the officers and grill them in his defense, in the absence of any statement made in 313. So therefore, the questionnaire has to be changed. Whatever the question is going to ask, we will confine him to the relevant questions are there, then we will examine that. Madam, the petitioner is agreed by the order dated, where is that order? Order dated 21/12/2024, passed by the, who has passed this order? Passed by the designated court, OPID Baleshwar, in ST case number 60/478 of 2023, whereby the application of the petitioner seeking recall, application of the petitioner to lead to call the witnesses for his call, as many as how many witnesses? Call 17 witnesses on his defense has been turned down. Mr. D.P. Thoro, that senior counsel submits that he would insist the application for calling at least the witness number 4, 7 and 14. 4, 7 and 14.
They are capacity
as they are locally based. As they are locally based. He on the query from the court, he submits that he would be furnishing the proposed questionnaires to be put to the said witnesses by next date of hearing, and the next date of hearing. Lease the matter. Let him do so within a week. Lease the matter and so on.
On 15th or 16th.
16th, 17th. Sorry. Get the proposed questions, and please apply to him and see the proposed questions, whether it is relevant for the purpose of whether it is classified information or not.
Yes.
Read what is a classified information.
Yes.
Under official secret act.
It's
Read. There are a couple of notifications also. You read that, then you address.
Yes.
Don't object in small case. He has now asked for adjournment. He has done this. He has done. Don't do that. These are very serious cases. You have to read it.
No.
And this is an occasion for you to know what is the official secret act. And there are many notifications.
Last witness was examined on month of December. I filed application in December itself.
Yes.
Not that number.
No, there is no delay, nothing.
Nothing.
22.
The Pund order it annex.
Application for adjournment. I don't know why the case is posted.
Next week. I have put it. Yes.
Only till that date.
Yes. Then good week for a video and then let him move application for adjournment. 1 week after. Okay, why to take pressure?
17th or 16th?
No, after 1 week, since I'm giving that liberty to move application for adjournment, let it be after 1 week. 22nd. Let it be on 22nd. You will have to prepare the questionnaires also. Yes. Yes.
May placement. Proceeding under the 130 NA Act, the petitioner has been convicted
Yes.
and directed to pay compensation.
148.
Instead of 52nd, can it be 21st?
Okay, 20. Yes.
Impugned order to Annexure 1, my lord. Relevant
What's
part.
wrong in it? You have been convicted, you have to pay.
Yes, so I will prefer appeal. In the appeal, while suspending the sentence, the Law and Appellate Court has a.
That's what happens nowadays after the amendment.
But as per the my lord settled position of law, this is not an absolute rule that the 20% shall be imposed in all cases.
It's not mandatory, it is directory. But
And
then the court can't do it at all.
And the court, yes, madam, and the court.
That 143 I can understand because there is no finding. Now there is a finding that you have been convicted.
No, I am only on the question of imposition of the condition, onerous condition of depositing of 20%.
That's not onerous. That is statutory.
Statutory, 20%.
No statutory obligations
that
are
is
onerous.
not, my lord, the mandatory that all courts while my lord suspending the sentence shall impose the condition of 20%, and the court while suspending the sentence.
Prima facie case, if you have.
So, but the Jambu Bhandari case is concerned, this question was raised. My lord,
I know that you tell me the prima facie case. Prima facie case. Prima facie, no case is made out. You show me that.
No, that I am not saying.
Then that is only consideration. Apparently, prima facie, no case is made out. Even if after conviction, if you can demonstrate, then it can be reduced. So show me that.
Okay.
Show me that.
I will file all the copies of the depositions and.
No, what you just satisfy me.
Only I am.
Show me the conviction order.
Yes.
That judgment has
show me the conviction order.
Annexed.
Conviction order I have not annexed.
He has not annexed the.
So you don't have a case, that is the reason. Yes. Read this paragraph. After this, do you have anything to say? Read loudly.
The accused has failed to give reasonable explanation and probable evidence to rebut the aforesaid legal presumption. Rather, he proved the case of the complaint by way of
the case on admission. Then
only I pray, my lord.
Nothing.
No, what I am saying.
How 20%? Na?
20%. That is my lord calculated as 1,80,000. Lordship, can it be on installment or that one?
Two installment you give.
Right. 2 installments, some time maybe.
Yes, right.
And what happened, my lord? In the meantime, warrant has
been issued. Order dated 7/3/2024. Will you give that?
Okay.
Give that judgment. Give that judgment. Yes. 7 whereby
the mind of the appellate court.
The petitioner is convicted by the court of the HDGM Bhadrak in ICC case number 323 of 2022 by judgment dated Kudi is by the name. Kudi is by the whereby the petitioner has been convicted for offence punishable under section 138 NIA and has been sentenced. What is the sentence?
6 months.
And has been sentenced
6 months.
to undergo 6 month SI
Compensation.
and to pay compensation
SI for
and pay
6
9 lakh,
9 lakh.
as compensation to the complainant against the said judgment of conviction and order of sentence. The petitioner has filed criminal appeal before which court?
09.
Session just page 12, madam.
12.
Yes.
12.
Criminal appeal no 9 of
Filed criminal appeal number 9 of 2024 before the district and sessions judge Bhadrak. The while admitting the appeal, the appellate court has directed the petitioner to deposit 20% of compensation amount under section 148 capital A of NIA. Also, petitioner is agreed by the same and has essayed the order in the present petition. I have perused the judgment of conviction recorded against the petitioner. And also the impugn order by which the appellate court is directed the petitioner to deposit 20% of the compensation amount. I find no legal information in the same, hence inclined to intervene the petitioner. Mr. Dwivedi appearing for the petitioner, however, submits that owing to his owing to the financial constraint of the petitioner may be allowed to deposit the compensation amount on itself. The prayer made by the petitioner being innocent, I am inclined to entertain the same. Petitioner to begin with to deposit 10% of the compensation amount within a period of 15 days, and for the remaining 10%, he may move for application before the trial court to deposit the same on installment basis. To this application, the petitioner is
as 10%, madam.
10% within 15 days, rest 10% to move application. Yes.
Yes, madam. In the meantime, madam, warrants have been issued that may be kept in evidence because I have annexed.
In view of the aforementioned order, the warrant issued, NBW issued against the petitioner by the order dated.
My daughter dated 1/3/2024 and 6/5/2024.
6/5/2024.
Under Annex 3 series.
6/5/2024 is stayed subject to the petitioner appearing before the appellate court on or before 25th of January. You won't appear. Yes.
23.
Appellant convicted under section 32 and 31E of the Defect sentenced to undergo arrest for 2 years.
2 years.
Bail fine.
2 years sentence, criminal appeal, admitted, bail granted, realizing of fine state, call for TRC, Mr. Das, appearance of Mr. Das.
25.
24. Then, my lord, this is that case, my lord. So I don't oppose his adjournment, but this is that case, my lord. Your lordship heard it extensively. Once your lordship aired your lordship view that in a trap case that too, my lord, say for extension of renewal license of that excise clerk, my lords. My lords,
the same view will be taken by any other courts also. Don't worry.
No, in fact, he took time. He got the thing time, my lords, to verify is there any to find out any new grounds. But
25.
May I please, your lordship?
Yes, madam.
This is the Belgium matter.
Yes, tell me.
NDW has been issued on dated 25/6/2024, and the petitioner released on bail on dated 14/7/2023.
23.
Okay.
14/7/23. 500. Yes. Appear on 25th. 25th of January. Yes.
26.
In a case of, in a complaint case, NBW has been issued your lordship on the order dated 18/7 of 2024, running page your lordship 19. After BW order of order dated 7/2 of 2024, running page 17 your lordship, in a case of 138 of the NI Act, wherein
1 minute, petitioner is accused in ICC 1CC case number 11 of 2020, pending in the court of SDGM Jharsuguda. Initially, bailable warrant was issued against the petitioner on 7/2/2024, and subsequently, due to non-appearance of the petitioner despite bailable warrant, NBW has been issued against him on 18/7/2024. On instructions, if paragraph 4 will appear on 25th, subject to petitioner paying a cost of rupees 1,000 to the local bar. Yes.
obliged.
37.
May I please, your lordship? My lord, this is a case of 138 NI Act, my lord. Initially, the accused was his personal attendance was dispensed with under section 205, my lord.
The accused in 1CC case number 137 of 2021, pending in the court of which court? SDGM. Badrak, JMFC, Badrak. Due to his initially he was
My lord, his appearance was dispensed with under section 205 CRPC.
Initially, his personal appearance was dispensed with by allowing an application under 205 CRPC. However, subsequent because of the subsequent non-appearance, the trial court has issued NBW against him by the order dated 26/11/2024. Okay. He will appear and give 1,000. Yes.
God bless me.
1,000.
At 28, the interim, he was the interim bail on 27 September.
Yes, interim bail. Yes, he was on the interim bail on date.
On 2024.
And on 8/11/24, my lord, a petition was filed on 370 CRPC was rejected.
8/11/24, 1,000. ठीक है, okay. नहीं 500. Allowed, sir, allowed. Yes.
May I please? NBW dated 16/9/20. Earlier, he released on bail 2/7/2013.
2013.
17/12/13.
24 is the
Bail date to 17/12/13.
500. Yes.
30.
Yes.
NBW issued on 10/4/24, my lord.
Yes.
Release on bail was 7/12/19, my lord.
Okay. 500. Yes.
Obliged.
31.
Lordship, NBW issued on 4/10/2024.
Sorry?
NBW issued on 4/10/2024, Your Lordship.
Yes. Bail?
Release on bail on 17/4/2013. By order dated 12/4/2013.
17/4/13.
Okay. NBW?
4/10/24.
500. Yes.
Okay.
Was issued on 29/11/24, and he was granted bail on 10/7/2014.
10/7/2014. Okay. 500.
32.
32 is done.
Himanshi Shekhar Barik.
Huh? 33. 34.
33.
In this case, petitioner were on bail, anticipatory bail, not annexed to in the event of arrest.
Lordship,
But
page
charge
18 may be perused, Your Lordship. Though the anticipatory bail was directed that he shall be released on bail by the arresting officer, and the petitioners were directed to appear before the IO.
They didn't appear.
Did not appear.
So on the request of IO, NBW has been issued.
Yes, Your Lordship.
Right. Petitioners, although were
annexed
admitted to anticipatory bail by the order dated 23/2/2020. However, they did not appear before the IO. Eventually, on the on the prayer of the IO, NBW has been issued against them a wide order dated 18/10/2022.
My lord, similarly, the
Oh, 1 minute, 2022. How many of you are there? Two.
My lord, two.
1,000 each. You pick.
My lord, Annexure 5 is same.
1,000 what? You are covered. You are citing judgment.
Judgment.
I'm allowing it. You don't want.
My lord.
1,000 each you paid.
My lord, oblige.
I'm allowing. I'm setting aside.
My lord.
I'm setting aside.
My
The NBW I'm setting aside 1,000 rupees.
My lord, oblige.
Local bar.
Oblige.
Okay. 1,000 each, two of you.
My lord.
Yeah.
34, my lord, same for.
Different PS case and same circumstances. He did not appear before the
Same for the
307
NBW.
NBW, my lord.
21/11/24.
21.
Anticipated bail.
My lord, 2020.
Is on 21/21.
21/11/2024.
Did not appear. On request the NBW was issued on 21/11/2024. ठीक है? Again same.
My lord, same person.
Again 1,000 each. Yes.
35. My lord, it cost 1,000.
1,000 each.
Oblige.
Obviously. Yes.
35 NBW order issued on 6/12/24 and he was in bail in 7/8/2024, my lord.
24. Okay. 500.
Oblige.
Local
applied the certified copy of the disposition order, praying for adjournment next week.
Next. Yes.
37.
37, may I please your lordship? My lord, he is in custody since 9/8/2024.
9/8.
Yeah, 9/8/2024 ରୁ ଅଛି. FIR date is 10/3/2023.
Yes.
Charge sheet submitted on 1/8/2023.
Yes.
My lord, the offences are under.
You are absconding. You are not.
My lord, I was there. But problem was that, my lord, 20B2C along with 29 and along with other IPC offences are there. The fact of the case, the prime accused person who was holding, having the contraband of 2.5 quintals of ganja, he took the ganja and he fled away. I was the only person who was halted the police persons. So, this is the I was not found in the possession. Caesar kichi bhi hai nahi.
That is there, but this present petitioner and others came and obstruct the police and assaulted to the police. But possession of the Vanja is the namely Benya Mohana
Biro.
What are their antecedents?
No antecedent, no. Absolutely. I'm a local person, no antecedent.
Yes.
Antecedent.
Nothing is recovered from him.
No, that is there.
Then what? that NDPS side, you keep it aside. What are the other offenses?
Other offenses?
Obstruction and all.
Only one person is there. That is there.
How many of them?
5 persons were there. Main prime accused, he took the ganja and he fled away.
Who is the prime accused?
Benya Mohan Biro.
Benya Mohan.
This is another person, Christo Raj Biro. This is a Garo loco. You
prevented the police. You allow the main accused to.
I admit, my lord. Murkho log aenge kiti kono ta bhitar jani pe jati gaan loka jaha.
What do you say? Any other evidence?
No other.
37 cannot be read against him.
No, my lord.
That is there, but injury report no.
What are the other offenses? Just
49 is there.
49 is there.
Because it is abated to commit the crime.
The abatement was 37 cannot be.
29 of the NDPS Act, my lord.
37 bar hobani seta pacharchen. 37 bar on jehetu possessor nahi.
God of force. Get some material.
Nahi kichi other offenses.
37 is barred or not?
37 is bar. Because the came and Gonja
get some judgment next 1 week for rakho. You satisfy me. Don't tell me the fact.
No.
Come with the law. Otherwise, I'll enlarge
No,
the
I will not. No, that I will not say.
Come with some law if you want. I'll put it next week. Huh?
Yes. Obliged.
Otherwise, he's entitled what to do.
Yes. I guess. Obliged.
Yes.
38.
Mr. Jana was saying that because 29 is there and all.
A statement of
So
the.
you get some judgment if 37 bar operates against it. Yes.
If your lordship say because the conscious position is not there, or that score is
Ultimately,
Spicer said that.
For bail, what consideration? Only these are the considerations. I'm not acquitting him.
No.
He pays it. Yes. Just tell me, I put it next week.
My lord.
Date may be fixed, my lord.
He'll fix it.
I guess. Obliged.
Yes.
38.
For item number 38, my lords, I'm appearing through VC.
Yes.
I pray for an passable, my lords. The counsel, Sri Sibo Mishra is engaged in otherwise.
Request is made.
Passable.
Mr.
Passover.
Passover you want or adjournment?
Yes, passable, my lords. I'm praying for passable.
Yes.
Much obliged, my lords.
39 Lordship, on behalf of Ms. Naidu, kindly taken up any other days.
Okay. Adjournment. Request.
40.
It's a case under section 420 and other allied offences, read section 66C and 66D of IT Act.
Yes.
My lord, here, my lord, the allegation that
Custody since?
My lord, 22/4/2024.
22/4/24. Okay.
The petitioner is a MSc student, my lord. And
why this matter has come to me? Have I dealt with it?
Yes. As per Pradhan Ijani, my lord, your lordship has.
No problem. Yes.
The cheating amount is 25,93,000. Last date, my lord says directed. What amount was transferred to this petitioner? I have filed the charge sheet, my lord. Kindly have a glance to page.
Yes, cyber crime.
The cyber crime nowadays is very.
My lord, kindly have a glance to page 38, my lord.
38, huh?
Yes.
Yes.
Item number 13. Last column. 1B, Ronit Patro has transferred only 50,000 to my account. One Ronit Patro, not the informant even. Ronit Patro, and that was also, police also held in his report, my lord. Page 45, my lord, kindly see.
45.
Yes.
Yes.
In last, towards the bottom, investigation at Sanchor/Jodhpur, Rajasthan. During further investigation, it has ascertained that the complainant deposited a sum of rupees 50,000 to the account of Praveen Kumar, this petitioner, by the account number such and such, undated such and such from Axis Bank, HSBC Bank. That is, my lord, in the.
What is the modus operandi? How have you operated? That's important.
What happened, my lord? One lady has called this informant. She in different time asked to put some money on their account so that he will in return for one answer he will get 5,000 each. Accordingly, he goes on depositing and he was duped. So far me is concerned, I was nothing, my lord. Maybe that lady
taking the money only.
No. Maybe that lady has stated that you.
Why your money is deposited in your account?
I also do not know, my lord.
No. You must be having some relation.
No. I have no phone call.
It is a group.
Yes, maybe.
It's create the group and dupe the people like this.
Yes, but
how many cases are there against you?
No cases, my lord. MSc student, no cases. Your lordship may reflect in the order.
This is how these.
And this petitioner, and my lord, so far this petitioner is concerned, he is ready to pay 50,000, my lord.
Not 50. No. It's not a matter of 50,000.
My lord,
the manner in which you operate is more dangerous.
My lord, I have not called.
You are duping everyone.
Not a single time, my lord, I have.
Now it is much dangerous than docket.
My lord, my lord, if I have made any call to the informant, that is different. I have never made any call even.
What you are appearing for?
I am in the sub item, my lordship.
You have the same.
Similar difference is that, my lords. Total financial liability, my lords, is 25 lakhs 93,000 some odd, my lords. So far as the financial liability against the petitioner is concerned, 5 lakh 98,000, my lords. Which the petitioner is ready to secure, my lords, as per lordship direction, my lords. Regarding merit of the case, my lords, petitioner is not named in the affair. No money has been transferred to the account of the petitioner. Money has been transferred to an account standing in the name of a company called MTP Enterprises. But there is no material to show whether I am the owner, proprietor, or somehow related to that enterprises.
How are you being
Millers.
entangled here?
No document has been seized regarding my complicity with that account. The mobile number associated with that ICICI Bank of a
What is the total amount involved?
25 lakhs 93,000.
Yes.
How many accused persons are there?
There are 6 to 7, my lord.
Regarding my liability, my lords, I am ready to secure, my lords,
My lord,
provide property
yes.
security and some cash.
May I pray, my lord, one thing. Is the cyber crime, many technical point is there.
I know that.
Yes.
I want to know the modus operandi.
Yes, my lord.
Operate.
One chance may be given. I will take in
Call the IO.
consideration. Yes, my lord. Yes.
Last
No, my lord.
I'll tell you.
My lord.
In any case, they are entitled to bail. Not
yes.
that you can't keep them for.
Yes.
Okay, they are entitled to bail.
My
But just understand whether these people are they are young
I have
people,
to-
engineers and all.
My lord.
Expectation of money, they have done all this.
My lord.
Yes.
So they are entitled. But let us understand.
I have to explain and what is the technical
Whether
point
they are-
and what is the.
There are going to be potential criminals in life.
No,
or
no,
not.
there are no.
Yes, I know.
Yes,
This
ma'am.
is very dangerous. All the IO, let us see.
Last occasion also, your lordship is directed to call the IO.
No.
Next week, any date, my lord, may be fixed.
Land council.
After 28th.
Nine, after 20.
ଆପଣ ଯାହାକୁ ଆୟୁ ନାହାନ୍ତି
IO na.
ଆୟୁ ଆଉଟ ଅଫ୍ ଷ୍ଟେସନ
ଆୟୁ କୁହନ୍ତୁ sir.
20 ପରେ ଟିକେ
ଆୟୁ କୁହନ୍ତୁ.
ରାଗୁନି
Adopted by
ମୁଁ ରାଗେ ନା।
petitioner to commit the crime is highly.
ରାଗ ମାନେ ମୁଁ ଜାଣିନି
Therefore, the IO needs to assess the court. Hence, he should adjournment so that on the next date of hearing, the IO of the present case
to 20th, my lord.
present
Thank
case would appear and explain the modus operandi adopted by the petitioner to bring to the complaint and other similar issues.
Oblige.
Lordship will fix a date so that you will come.
They will.
Kete koi din date. I would okay, pura.
If the problem is neither the IO is able to understand the modus operandi.
No, they,
Now the court.
they,
You took the advantage.
my lord, they,
Actually, defending advocate also doesn't know.
my lord,
None of us knows. Only those people only know. That advantage there. You are also. I am 100% sure you don't know.
No.
And he also doesn't know.
what the charge is that I'm saying, my lord.
Doesn't know the IO partly knows it.
Absolutely.
The brief fact, the elaborately have discussed in
These people are these engineers and all. They are
My lord. He is a
they are
technical.
potential criminals nowadays.
My lord.
Let us understand to what extent they have done it.
24. My lord. Oblige.
41.
Yes.
Well, in this case, the petitioner has been remanded in a case under section 20B2C, not from the spot. In a Bolero vehicle, 200 kgs of contraband ganja was seized.
200.
200, my lord. Well, 2 persons were apprehended from the spot. And basing on their confessional statement, I have been arraigned in this case, madam. That is the implication.
No. The present petitioner was in the vehicle. The fled away from this spot. Yes, you are present there.
But
what is the evidence? Anybody has said that anybody has seen?
Yes, my lord.
Fleeing away from the spot.
Yes, statement.
Custody since?
The custody, that particular custody, because he has been remanded in this case, my lord, more than 2 months, my lord, in custody.
2 months only. And how many cases you have?
My lord, arrested in one case and subsequently in two cases he has been.
Similar type of is the habitual.
Put it up 3 weeks later.
A particular date may kindly be.
No, 3-4 weeks.
42. And here the lot, sir. Here the petitioner is in custody since 9th April 2024. The FIR was lost under section 307, torn to 302, and charge sheet has been filed on 16/7/2024.
16/7?
2024.
Yes.
Now, so far as the allegation as would be revealed from the FIR which I have annexed,
Statement of the deceased recorded?
deceased was not recorded.
161?
I will take
Line declaration?
so 302 is here up to CD my record.
My lord, here the charge sheet has been filed. One thing your lordship may.
Yes, I'll opted.
I'm not there. So far as the charge sheet and other materials are concerned, now I have with me the copies.
Give it.
I'm giving one more aspect. On 8th, mother of the petitioner has died. I have got the information with the certificate of.
Have you moved the application?
Because yesterday night only I have got the information. So I was expecting either this will be taken up if the materials have been brought on record, or else your lordship may take.
When he died, when she died?
Day before 8th Tarik dino. On 8th only.
Verify.
Yes.
Your lordship may take up on Monday.
Verify.
Friday.
Give
Tuesday.
Tuesday କେମିତି ହବ ଛୁଟି ଅଛି ପୁରା 8 ତାରିଖରେ expire କରିଛି.
Wednesday.
Wednesday it will take.
Wednesday I'll definitely.
By the time I will get and the copy and other thing, maybe the 10th of CQ over. That's why. Otherwise, I would not have prayed even.
Okay, verify.
Yes.
Monday, I'm handing over a copy to my friends.
Yes. For the petitioner submits that the mother of the present petitioner is expired on
8th
January. And he has submitted the document to that effect. Accounts for the state to verify the same. At least the matter for the consideration. Consideration for interim bail. Interim bail. Monday.
Your lordship may kindly be pleased to record that I have handed over the entire.
I've shared that.
Grateful.
Yes.
Grateful.
May I please, your lordship, item 38, last occasion your lordship directed to file an affidavit regarding antecedent. Affidavit not filed.
Let it be
Yes. Urgent matter.
Yes.
Urgent.
Passport is urgent.
Urgent.
Yes.
43.
Yes, sir.
43 may I please?
Yes.
During this.
I am for the respondent. The review filed with the state against the order of FAO, wherein the FAO has been disposed of on the ground of delay of more than 1197 days. And your lordship on a similar matter disposed of.
There is a technical problem here, my lord.
I understand it. There is a typo error.
My lord.
Then typo errors are not assigned to this bench. Only review.
So if your lordship is here, then I have no objection. But
no, I can't. You have to get it clarified.
That is the order, my lord, and that normally the office is corrected after bringing the court, my lord, they corrected the day.
But yes. Who has done it in the year? It is already done. Who has done it?
2018.
This is 2018.
It should be 2016.
Huh?
2016. 18.
Good 18. So let's do 18. 16. 80 order that. Order. 80 that.
No, right.
Yes.
One page is actual number to get.
So you moved an application for typographical correction of typographical error.
My lord.
Have you moved the application?
Not. It's good. The records there's no so that.
No, have you moved the application? What that's the
Verified
problem
from the office, my lord, because the typographical your lordship mechanism, the order operating part 779 that has been mentioned. But in the FAO number, it is 499 of disaster.
नहीं, what is this now review petition?
14/3/2018 order টা এলো। The last paragraph, in view of the above order, miscase number so and so, the FAO stand dismissed. FAO number to corrected is 499. না, 16 over.
Miscase not a top of the order, not correctly mentioned. That is 779116.
But in any case, on merit, you don't have a case.
Yes.
चलो dismiss तो करना है क्या?
I am the जिसे अपन similar order दीजिए.
I'll dismiss it, finish it up.
But here, my lord, the problem is.
It is
The Lordship has already
732
passed the
days.
order. The Lordship has already passed the order in similar matters. But on the same time, my lord, there is a in my petition, it indicates that some matters in pending similar matter, the condonation of delay dismissed, and your Lordship may kindly see the page. So I have to take instruction whether what is this practice of the similar matter, right? Page 27, the Lordship may kindly see page annexed 2.
20?
Page 27.
Yes.
Annexed 2.
Yes, yes, that has already been disposed of. That yes, yes, already on remand. Again, the matter was disposed on merit.
But whatever, but how review is maintained? If you want to say anything, I'll adjourn it.
Normally, the Supreme Court is high to file. But the fact remains, my lord, there are some grounds. The Honorable Court has not taken
The
it.
grounds are in appeal, not
appeal.
review.
But appeal was dismissed solely on the ground of because at the time of condonation of delay,
I'm just simply adjourning it to next week. Just you tell me how to go about it. If the last part of the order is in view of the above order, miss case number 779 for 2018, and the FO stands disposed. 2716 it should be.
Yes.
First, you have to move an application for correction of this.
Verify.
You move a miscellaneous application in this review petition. For correction of that. Then I'll see. Okay. Put it up to 2 weeks. Yes. And just come.
OP number 4.
Who is for
The private party, my lord. Om Prakash versus Kumar Gita Bara.
Pass out.
Service 123 insufficient, madam.
Then
6, 8, and 9 out of session. 11, 14, 15, 16 left without instruction.
petitioner to take the necessary steps to serve unserved respondents. These the matter. Yes.
My lords, item 44 minutes, I'm appealing for the petition minutes.
Yes, there are a few unserved respondent you have to take steps.
My lords, subject to my lords approval, my lords. My lords, OP 5, 12, and 13, my lords, the noting has come out that they are deceased. My lords, with respect to OP 5, 12, and 13, my lords, I shall take steps for substitution, my lords. My lords, with respect to the other OPs in the noting, wherein it has been stated that the notice is insufficient, my lords. But I humbly state that these particular OPs, my lords, are now contesting the petitions, the judgment debtor, my lords. These OPs, with respect to whom the notice has been written as insufficient, my lords, they are, my lords, contesting aggressively before the executing court. But subject to my lords' acceptance, my lords, since they're not accepting notice, I shall take steps for paper publication.
Steps for
paper publication, my lords, under order 5 rule 20, my lords.
You move application, detail application.
My lords, I'll move an application under order 5 rule 20 for paper publication of these particular OPs with respect to
submits that he would be moving application for substituted service insofar as the unserved respondents are concerned. Let him do so within a week, least the matter of case. Yes, you move an application.
Grateful, my lords.
46.
46.
My lord. It's a simple modification. My cost title, my lord, in my cost title, order of cognizance dated is correct. 18/6/2013. My lordship got it.
18/6/2013.
That is my cost title. Inadvertently, my lord, while passing your lordship's order, typographically, in place of 2013, it is typed as 23. 18/6/2023. In paragraph 2, paragraph 3 in the
18/6/2023. But in prayer, what have you written?
Pardon?
In a prayer of your petition, just see. What have you written?
Cognizance dated 18/6/2013.
13.
Yes.
13 is correct.
Correct. That is my cost title is correct.
No. 13 is correct then.
13 is correct. Inadvertent.
It has come as 18.
Yes, right as 23. 18/6/2023.
So it should be 1-3 instead of 2-3.
2-3. Your lordship has specifically observed order of cognizance dated. That is valid only because of that he is not acting upon that order.
8/2024, right?
In paragraph 8 also.
The order of cognizance, the 18/6/2023, you see, 13 over.
Paragraph 8 re madhya. Paragraph 8.
3 and 8. 3 and 8.
एत्ते परे में
ठीक है. Allowed. Application allowed. Yes.
47.
May I please, my lord?
On behalf of SN Mishra, may I pursue the matter, my lord? Kindly have a glance with the last order dated 13/9/23. Notice was issued to the opposite party who is the informant, my lord. Notice was sufficient, my lord. But she didn't make any answer. My lord, petitioners are ladies challenges the cognizance taken by learned special judge Puri under section 3(1) SC/ST, 2 VA SC/ST and POA Act, my lord. That is 5/4/2021. That is Annexure 1, my lord, page 6 and 7. And when FIR lodged against petitioners and 2 others under section 307 along with other allied offences. So they approached this honorable court for anticipatory bail.
Let this opposite party be served through the IIC.
Apart from that, your lordship may directly correct the cost title because he stated that PS case number 2010. For that reason, my lord, we have called for CT for thrice. Then
you have not corrected.
Cost title टा देखो ठीक
है.
PS case number 312 of 2002 सेटा 2020 होगा. ना GR case टा पर 2020 लिखो. ଆଚ୍ଛା IO stated that ସେଭଳିଆ ଆମର
PS
registration
case
ହେଇନି।
ନବ।
And I verified that
that's
GR case
correct.
ନଟା GR ପଡିଯାଉଛି ତେଣୁ ଏଇଥିପାଇଁ
At the top.
2010
ଆଉ ଭିତରେ କୋଉ ପାର୍ଟରେ ବି କିଛି ଲେଖିନାହାନ୍ତି ସେ PS case number।
2020 ହବ।
You correct.
Yes,
And
yes,
counsel
right.
for the petitioner submits that there is a typographical error occurred in the first page of the petition. He wants to carry out the correction insofar as PS case number is concerned. Let him do so. The respondent may be served through the IIC, which police station? Satyavadi.
Yes, Satyavadi.
Satyavadi PS is directed to serve the opposite party number 2. Leave the matter on session after 3.
Lordship say responded opposite party.
Opposite party, yes.
48.
Yes. Defects remove? Huh?
44 defects.
Huh?
44 defects is there.
Defects is not included. On the last date of hearing, the learned counsel for the petitioner was directed to remove the defects pointed out by the registry. However, the same has not yet been cured. By way of last opportunity, 1 week time is granted to cure the defects. It is made clear that if within 1 week the defects are not cured, the petition shall stand dismissed without reference to the court. Yes. If the defects are cured, leave the matter after that. Yes.
49.
Interim order better.
If defects are cured,
11/24 may be extended. That was listed on 1912 at serial number 108, but it could not reach. I have mentioned that Lordship has extended the stay order, but it was not reflected in the order sheet.
Which order?
That is
Dated?
11/11/2024.
Interim order pass, it shall continue. It's written.
Yes, yes, that is to be extended.
Continue when the matter is now listed. It is extended. What do you want exactly?
I want that order to be extended to the next hearing date.
Next date, when is the next date? Today is the next date.
Lordship may take up the hearing. No objection.
My lord, I am appearing for the informator in this case. Pray for a direction to give me a copy in order to file an objection.
Yes, I will give him copy.
For opposite party, number 2, and submit that he has not received the copy of the petition, and counsel for the petitioner to supply the copy of the entire paperwork. Lease the matter on Thursday. The interim order dated 11/9/2024 shall continue to lease the away. Yes.
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 50.
Ask for a time. 50.
51 pass over.
50 of the paras passed over adjournment summons.
Opposite party. So and so entered appearance on behalf of the opposite party. Number 2, on behalf of the petitioner, the adjournment. The opposite party is at liberty to file a response to the petition. Release the matter. March last week. Yes.
51.
51, my lord. One pass over, Mr. Rautraj.
51.
My lord.
51 रे notice जेतला private opposite party 2 को
Answered. Notice
माने आमे IIC थ्रू रे ये करछु किंतु एके acknowledgement आसीनी जदि पास ओवर होछि रहू किंतु एटा
फायदा नहीं ना तो for the notice was by the order dated 28/11/2024. Notice was directed to her through the IIC Tangara Police PS. However, the report of service has not yet been received by the counsel for the state. Lease the matter after 2 weeks. Yes.
Arjun.
Report hasn't come.
My
Service on responsibility.
My lord.
Yes. 52.
My lord. Notice, noting is there, notice returned unserved as because the address is as left. Though that is the correct address according to the one CC case.
Issue notice subject to deposit of 20% under the 143A of the NI Act. Your lordship.
সেটা অর্ডারে নাই।
No, nahi je, I have my order is reflecting. I am not bringing the notice to one
Subject to
court.
the petition deposited. Have you deposited?
No, my lord, there is no direction that where to deposit and the mode.
This is very clear, subject to the petitioner depositing 20% of check amount in accordance with the requirement of section so and so, issue notice. Deposited in the trial court.
Yes, your lordship, my direct so.
By order dated 19/12/2024, notice was issued to opposite party number 2, subject to the petitioner depositing 20% above the check amount in accordance with section 143 capital A of NI. Then counsel for the petitioner submits that since the order is not clear as to where the deposit has to be made, he could not make the deposit. Needless to say that the petitioner is required to deposit 20% of the compensation amount, interim compensation amount before the court below. Let him do so within a week, and fresh steps may be taken by the petitioner. Shall be taken by the petitioner.
I may kindly be permitted 15 days.
15 days, okay, 15 days, and fresh steps shall be taken by the petitioner to serve respondent number 2. Yes, sir. Please, madam. Yes.
Notice was made, though the address is sufficient.
You
But,
do first deposit, let us see. Yes. Once you deposit, he'll come to take the money. Then he'll cut off.
Definitely, as you point.
I will deposit, but it should not be released in favor of the complainant.
That you can, I have so only said that deposit, that's all.
Yes, but it may not be released.
We'll see. Yes, next.
May please, your lordship. This is a modification for extension of time, your lordship.
Extension of time.
Lordship.
I asked you to deposit, surrender before.
JMFC Lakshmipur.
Surrender before which court?
Lordship JMFC Lakshmipur.
For the reasons stated in the application, the same is allowed. Time to surrender or appear before the court by the petitioner is extended up to 25th of January. It is made clear that no further extension shall be granted.
Deeply obliged.
54.
My lord, this is the case of.
Before starting submission, my lord, and come, thank your lordship. In this case, what happened? The present prisoner seeks for the custody of his minor child, your lordship. Now the minor child is in trust home, child welfare center, your lordship. Despite earlier occasion, the notice is issued directed to requisites to file by tomorrow. Despite that, notice has been not filed. Nobody has entered appearance for the CWC, your lordship. And my respected submission, lordship, that kindly
In my lord, we have filed the requisites.
That fresh notice you, your lordship. But pila chori kori ki petition nahi ki padela po pila jio gur chadi po gu nahi padela. But then se recovery la pare, but then ye bail lagala pare, se pila but then CWC re achi. But then se custody ta maguchi learn trial.
Same day requisite has already been filed by it. Same day requisite.
No, whatever, the small child, it has to go to the.
6 months child.
6 month child, the Mapaku Japan, I am not disputing, but now the child is.
Why after service, why these people are not coming?
Not service.
What is this? Service is complete.
Yes, my lord, we have filed.
Aji file for the requisite for issuance of notice.
No, my lord, we have filed. No, we have filed on.
When there is.
People are very casual. Last time also you didn't file.
On the same day, your lordship direction.
On the same date, we filed, my lord.
Sir, opposite party number 2, 7 and 8, 7 and 8 through the IIC. Which IIC? IIC, which police station?
Baleswar town PSI.
And list it on 16. Sir, immediately.
Yes, sir. Extra copy.
Give extra copy.
Yeah, yes, my lord.
Just now you give it.
Okay, my lord.
Yes. 16, huh? Yes.
If I let us pass on this matter. Whether your lordship will hear this matter and will pass judgment, because Mr. Bagada on the last party then initiate draft case. And all
It
total.
needs hearing.
All
hearing.
total 11 BWs and 1 BW have been examined. So.
I'll put it, देखो next,
Possible dispose.
अगर next week कर देखेंगे. This is a hearing matter, I can't hear it. Yes. Next.
Next.
56 last occasion notices were directed to sought to the IAC. Informant, my friend
Yes,
will suggest.
service.
Your Lordship, despite the efforts made by the learned to the IAC, is not traced out, Your Lordship.
Another 10 days.
Opinion number 2 in
Another 10 days will be to trace our out.
traced out no se bhada ghara chhadi pali ju dan kis miluni ta fare about that op
As
2
in, बच्चे की मर्जी आगे देखो.
that is the instruction, Your Lordship.
No, he is the informant.
Yes, Your
She is
Lordship.
the informant.
He is the informant. If you can't locate him, how will you lead the evidence?
Now
How
the
can I
case,
also?
but facts mean the
Evidence against him. Search him. Search her. Otherwise, see, in any case, it has to be quashed.
the address which is given in the time of lodging of affair, in that address, IAC already been searched and give report that now she is
You
not.
tell me one thing, if you can't search out the
Yes, sir,
informant, how will you establish the case against her?
Yes.
That's right, Your Lordship.
Even if try to take commences.
That's right, Your Lordship.
Further 15 days time is granted to the IIC Lakshmi Police Station to serve on the opposite party number 2. Leave the matter in March रखियो. Interim order pass earlier shall continue.
Engineering chakri होगी.
Interim order shall continue. So that at least you know what is the outcome now. Yes. Yes, sir.
May it please your lordship. My lord, the petitioner is working as a nurse in government hospital, your lordship. The petitioner has prayed for quashing of the proceeding initiated against her, which is here outcome of the previous civil dispute pending since 2018 as per Annexure 5. And only your lordship to harass me because I am working in the government as a nurse. And I have been appreciated for my work only to settle score, private score and this civil dispute. This case has been filed. Your lordship may kindly permit me to place only one line, that is page 16 of the FIR, wherein it is stated that on 30th of July 2022 at 8:30 a.m. this dispute happened.
13th July.
Page 16, your lordship. At 8:30 a.m.
Aji ସକାଳ 8ଟା.
Yes, that is on 30th of July. On 30th of July at 8:30 a.m., the informant says while she was standing near her house, my lord, here the case is that, your lordship, the informant and accused person, informant family, accused person, they are all belonging to one family. Previously, they were staying together. They have joint property. Later on, dispute arose for which civil suits were filed, and for that reason, both parties, your lordship, are at daggers drawn now, and this case is an outcome of that. Informant says on 8:30 a.m. in the morning, when she was present, 4 people entered into her house.
Ready.
My lord, my role is that I came later on and joined with these 4 people, and my husband came later on. He also joined. They dragged the
Both of you scolded and
assaulted. This is the allegation.
All this.
She is the assailant. She is the assailant.
I am coming to that, your lordship. So on this allegation, your lordship, police investigated the matter, and 41A notice was issued to us. 41A notice.
These are not relevant for.
My
Tell me, charge sheet, what has come?
Charge sheet, your lordship, that is 452, 341, 320.
No, what are the this incident is ascertained by the police?
Yes.
And file the charge sheet. Cognizance is taken. What can I do?
My lord. Your lordship may kindly see.
And whatever you are saying, past enmity and all, that has to be established.
Yes. Your lordship may kindly permit me to place Annexure 7.
Yes, 7.
Annexure 7 of my CRLMC page 45.
Yes.
My lord. This is the information which I have obtained under RTI, your lordship. Your lordship may kindly see page 46, the last one.
Yes.
Pushpa Manjari Raut. I was in night duty. My lord.
Establish.
Your lordship may only.
These are simple things. We need not labor on this.
My lord.
This please has to be established. Plea of alibi is a matter of fact, it has to be established.
This document, your lordship, can take into consideration this proceeding. Your lordship may kindly permit me. Only one.
Not any cognizance.
Yes, I'm only, my lord. This is a very.
EPF alibi has to be established.
My lord, this is a very recent judgment passed just few days before. I'm reading only the same plea was taken. Paragraph 8 I am reading. Wherein the State Council also took a plea that since charge sheet has been filed, he can raise all these points in the charge at the time of framing of charge.
You go and argue that.
Your lordship, paragraph 8 that has been no.
Charge you argue.
No, my lord. That is exactly what has been negated.
Yes.
Paragraph 8 I am reading.
Yes.
My lord.
Yes. Fact
to fact different, your lordship. And your lordship may kindly permit me to take it. Paragraph 8. It is true that the applicants can apply for discharge. However, the scope of the application for discharge is completely different from the scope of petition for quashing of the criminal proceeding.
Where is the plea of alibi in this case?
Just, your lordship, I am reading. There is a written, your lordship. I am reading. While arguing a case for discharge, the applicants will not be in a position to rely upon the documents which is not part of the charge sheet. The ground of abuse of process of law will not be available while arguing discharge application. However, in a petition for quashing, either under section 482 of the Code of Criminal Procedure or under 226 of the Constitution, a wider challenge is available, including challenge on the ground of abuse of process of law. In such proceedings,
there is no quarrel on this.
My lord, in such proceedings, the accused, my lord, just this line, my lord, in such proceedings, the accused can rely upon documents which are not the part of the charge sheet. Therefore, we reject the submission made by learned counsel appearing for the state. Though the submissions made on behalf of the state have no basis, we have dealt with the same elaborately to ensure that the same are not urged in similar cases.
I am entertaining this.
My lord,
I have applied mine insofar as you are.
Yes, your lordship.
Documents are concerned. What I am saying is this has to be proved on record.
My lord, this document, your lordship, I have obtained under RTI. It shows on that why I am submitting, your lordship, because of some reason, my lord. When this case was filed, I was selected for my work to go abroad by Government of India. Appreciating my work, I was selected. Because of this criminal case pending, in passport verification, it was objected. Your lordship has been kind enough to issue notice and permitted me to take adjournment in the court below. I took adjournment. Passport clearance was done. Your lordship, recently also, my lord may kindly see.
Now you got back your passport?
I attended that program sponsored by Government of India. My prayer before your lordship, prima facie the documents established that 8:30 AM I was very much in my duty, my lord. In government hospital I was in duty. Yes. Now if a person, my lord, could be entangled like this and she has to face trial, rest accused persons are there, let them face trial. And your lordship may kindly see, this is the statement. If only one statement I will read, your lordship will consider that this is a case to be made out against me. Only, my lord, one statement I will read. Total 8 witnesses are there.
Yes. Yes.
My lord. So for the first one is the all similar witnesses typewritten. First one I am reading very quickly, my lord.
Relevant part you read. Don't read.
My lord.
Yes.
Relevant part. Entire पढ़ दो जाए clear है जो. मोना शैलेंद्र कुमार मिश्रा जी आपन का अगर दौथुआ मोर बयकुवन जे मिथुन सिद्धार्थ जेना happens to my husband. सिद्धार्थ जेना नटू जजाति जेना प्रकाश जेना पड़ोसी अटू से परस्पर कुटुंब भाई अटंदी मो पिला बेलू मु देखि आछी जे ए जगह बंशीधर जेना जे कि नाटू और मरकर जेना बापा से सेटलमेंट सुपरवाइजर भाई चाकरी करथिले मिथुन बापा बैंक मैनेजर थिले सेटार सबु परिवार एकाठी रहउथिले किंतु गंगाधर जेना चाकरी अवसर नेला परे आमे जानलु जे जगहटी तांको नारे कबला होईची बंशीधर जेना गंगाधर जेना बेसी कथा होई ए ओडाटू को तुटै दबा तांको गां रे सबु जमी एकाठी अछि तनु गां रे अपुरी जगह सबु बांटी दबा ए हेले यार भीतर गंगाधर जेना हृदघात रे मृत्युवरण कले या परे गंगाधर बाबू स्त्री और पिला माने जजाति जेना मरकत जेना प्रकाश जेना घर छाड़ी देई घर छाड़िया पई कहले न छाड़ले घर दुकान में भड़ा देवा पई कहले किंतु सबु घरे समस्त मिसी करंती
You first tell me what is the distance between the place of occurrence and the hospital.
That is at a distance around 5 kilometers.
No, 1 kilometer.
That those are the facts to be established.
My lord.
8:30 you left the office. In the FIR it is written 8:30.
My lord.
Whether exact 8:30 or 15 minutes here and there, I will decide it here.
What are you talking? My lord, these 8 statements, entire, my lord, your lordship will consider that the
8:30 your duty is over.
That is over.
What is the distance between? These are the questions to be put to the witnesses. And you establish it is not possible to
I
travel
got
such a
on.
distance.
As your lordship said, in the charge.
Merely in the FIR it is written 8:30, doesn't mean that it
Doesn't mean your
maybe
lordship.
5 minutes here.
Never, yes, your lordship. But as your lordship said, the investigation, it is to be ascertained that a case is made out against me, my lord.
It's made out.
No, my lord. These are the 8 statements. Not a single line has been implicated by
So
anyone.
you argue at this stage of charge, all this thing. Cognizance prima facie case is made out.
These 8
It is
statements.
charge
with
stage,
your lordship,
perhaps you make out a case. Charge stage you can make out a case.
that I bow down, my lord. The same thing, your lordship, I refer the judgment wherein it is said that your lordship.
See, I can't read the evidence of the 161 statement of all the witnesses and appreciate
No, only 8 witnesses.
and try and make out a case.
My lord, only 8 witnesses. And all
FIR is very
stereotype,
clear.
all stereotype.
Allegation made in the FIR is very clear.
Nobody,
And injury is there.
and the statement he says, ଉଭୟ ପକ୍ଷ ଖଣ୍ଡିଆ ଖବର ହେଲେ ଡାକ୍ତରଖାନା ଗଲେ ଥାନାରେ କେସ୍ ହେଲେ ଏହି ଜମିବାଡି ବିବାଦ ସେ ଦୁଇ ପକ୍ଷ ନ ବୁଝିଲେ ଏହାର କୌଣସି ସମାଧାନ ହେଇପାରିବ ନାହିଁ. This is your lordship the statement.
Is not made out.
My lord, there is no allegation against me. ଉଭୟ ପକ୍ଷ ଆଜ୍ଞା ଗଣ୍ଡଗୋଳ ହେଲେ.
Ubhay Pakere, whether you are there in that Ubhay Pakya,
My lord,
who knows?
my
That
lord,
has to be, you have to distinguish that in the charge stage. You say that in the both the group, I may not be there because I was somewhere else.
That is again your
On
lordship,
that
this
day.
restriction in charge. I cannot produce these documents, cannot be considered. Which
That you rely upon this judgment. This
the
judgment.
judgment says in charge it cannot be, it can only be in quashing. Because in quashing, your lordship, the scope under section 482 and 226 of the constitution is quite wider, and the honorable Supreme Court said in charge these documents cannot be.
I will deal with the document and pass an order.
My lord.
And the document which is supporting you today, I will dilute it by saying something. It will create problem. Leave it open. So you have a clear case of alibi. You can very well establish that. If you invite some observation at this stage, cognizance stage, it
That
may
will
make
definitely,
problem
Lordship.
for you.
Police has granted 41 a notice to us, even we have appeared. Thereafter, I could know.
Therefore, see, the apparent problem is taken care of. First is no arrest.
My lord.
Second is your passport that I have given indulgence in another petition. And you attended your conference and all. This is immediate problems are taken care of.
My lord.
And you have a valid document, plea of alibi. You can easily establish it.
Your lordship may observe that I will take this please in the.
Yes, of course. Of course. Petitioner is in the present petition is seeking quashing of the order of cognizance dated 17/11/2022 passed by the learned Puri in GR case number 1606 of 2022, whereby the court below has taken cognizance of offences punishable under section 452, 341, 323, 506, 354, 34 IPC against the petitioner besides other accused persons. Let and counsel, Mr. Mishra, let and counsel for the petitioner, relying upon the RTI information obtained from the TB and ID hospital Puri, submits that on the date of the incident, the petitioner was attending his official duty in the hospital from 9:15 p.m. to 8:30 a.m. On the strength of the said document, he submits that he had a clear case of alibi. And he has also relied upon the judgment, relied upon the judgment of the Honorable Supreme Court.
Paragraph 8.
Paragraph 8. It submits that the documents he relying upon to seeking quashing of those
Annexure 7
can be gone into in the quashing procedure. I'm not inclined to entertain this petition at this stage for cognizance, because the plea of alibi being a question posed with facts need to be established during the trial. Be that as it may, the dismissal of the present petition shall not preclude the petitioner to approach the trial court for discharge. by moving appropriate application. If such
My
application.
lord, may only one prayer, your lordship. Since I am submitting all the statements wherein my involvement is not there, your lordship may kindly only add one line that the learned trial court, let the learned trial court verify the statements of 161. I know that, your lordship. I know that, my lord. I know. But your lordship, but if your lordship will observe.
Do you think that you move an application, the trial court close the eye and pass the order?
My lord.
I'll say that you
My
read
lord,
this, you
my
do
lord,
it. Where specific allegation is.
I do not dispute, but in
Our job, please.
my lord. But let the learned trial court.
Next item.
My lord, my lord,
I think sufficient intelligence.
my lord, my lord may only observe one line, as in another case, your lordship has said.
I have no
Let him-
advise the
Let
trial
him,
court to
let
do
him, my
something.
lord, let him answer specifically whether the
He will
offenses
do
are.
it. If he doesn't do it, then that's a different story.
Because again, your lordship, only, it is not observed, again I have to come. So that is the.
They generally trial court pass a very detailed order in this kind of situation.
Fair,
Rather
very
we
specific
do
allegation
short
is
job.
against her.
They do detail. So don't worry about it. Yes. Next.
Your Lordship, may it please the court. Your Lordship, on behalf of Mr. Ashok Parija, I appear on behalf of the petitioner in the first matter. Your Lordship, Mr. Parija has been recently engaged in the matter, and Mr. Prafulla Ratha is appearing on behalf of the petitioner in the second matter. Your Lordship, I seek a short accommodation in this matter. If this
I'm
matter.
highly intimidated by all these array of illustrious names. I will only, my lord, Lordship take a short date, my lord, have it.
Monday,
But my Lordship fix the time and no interim order. No, I'm opposing the interim order.
There was no
This is a classic case of forum shopping. My lord, I'll your lordship.
There was no interim order.
No,
Your Lordship, Your Lordship, there's an interim order dated 14
There is
August.
one, I filed a vacation in the first one.
We have filed objection to that.
I filed a.
No. The first order, for the first matter, there is no interim order.
Your Lordship, there's an interim order.
I'm not saying anything, simply adjourning.
Your Lordship,
On behalf of
there's an interim order dated 14 August 2024.
Petitioner, an adjournment is sought on the personal ground. Matter is adjourned to.
Your Lordship, am I audible?
20 seconds. 20 seconds. Okay.
Your Lordship, there is an interim order in the first.
Next week, my lord.
Next week is very, very tough.
Can we have it at 2 p.m.?
2 p.m. makes neither here nor there, you know. I can pay, I put it at 2 o'clock, no problem.
No, I'll
Let it be 2 o'clock.
I'll leave it to your lordship's convenience.
Your Lordship, am I audible?
Let it be 3 o'clock. Better that all the miscellaneous matter will be over at 3 o'clock.
Great.
Yes.
This might take a little bit of time, but
Yes.
no.
Yes.
Great.
Your Lordship, am I audible?
Yes, done, sir. Whatever you say, I have done it.
Your Lordship, there's an interim order in the first item.
But if it is there, it is there. I'm not saying anything. Yes. Next.
Lordship, Your Lordship, I'm grateful.
I am for the complaint.
You go to 90.
I am for the complaint and opposite party.
Yes.
Lordship may see Lordship's last order. 8th of January 2025.
8th January, yes.
Should I place my note?
Yes, sir.
Both the parties have preliminarily agreed to settle the dispute. Mr. Acharya Lanan, senior advocate appearing for the petitioner, would circulate the
Yes,
draft settlement.
Yes,
My lord. Not yet circulated, my lord.
With my associate,
The consequence has to be followed, my lord.
Yes, Mr. Acharya, what is this? You have not circulated.
No, actually the problem was the petitioner is out of station, out of the country, so I could not contact her. I could reach her yesterday evening, so we are just circulating the draft, my lord. It's already
Yes,
there. Yes, my lord.
Hey, are you agreeable to this?
The same thing what I
To obtain instruction.
it is written there.
Agreeable to it? Yes, see. The petitioner shall pay total amount of 9 crores in 8 installments. Opposite party also.
Without going to the petitioner shall pay total amount of 9 crore in 8 equal installments to the opposite party each month. The payment of installments starts from 7th of March. My lordship, on the last occasion, directed at the upfront they must deposit some amount to show their bona fideness.
No, this is the proposal given by them.
My lord, I'll take instruction again on that.
You take instruction?
My lord.
Monday?
Monday.
Not Monday.
Interim orders to continue, my lord. Interim order to continue, my lord.
Interim order 16, huh? 16.
My lord.
Okay.
Your lordship, the interim order to continue.
Mr. Uttamacharya, learned senior counsel, has circulated the draft settlement proposal to the counsel for the opposite party. The opposite party seek instruction in that regard. Release the matter. Yes.
My lord is fixing to 16.
16. Yes.
Interim orders to continue, my lord.
Interim order to continue. Yes. Next.
61. My lord, I am challenging person on the FIR, my lord. On the ground that, my lord, since my lord,
Lordship permits not.
proceeding, my lord. And last occasion, the lordship directed the council.
Yes, my
the
lord.
president to take
That's
instructions. In the meantime, my lord, to
Morana is in a fixed mode, sir. Mr. Morana is in a fixed mode.
Oh. Mr. Marana appearing for
In fact, the case was lost.
the last
Vigilance Department, Vigilance Department in this post, he's not well.
next, ये भीतर चार्जशीट कर दियो तो कर भी ना
This post.
Okay, instruction filing a charge sheet.
Mr. On his behalf, Mr. Sangram Das is keeping in accommodation. Leave the matter in the court.
Anyway, I'll get that instruction tips about the charge sheet.
short day.
Short date. Yes.
62.
I am here to open over to the information. Lordship, I think this is a very serious, peculiar case.
Come to the front.
My lord.
OP number 2 doesn't mean that you will be in the second row. Yes.
Well, the real admitted fact, my lord, your lordship.
Who is for petitioner? You are appearing for petitioner, ma'am? Yes, madam.
Yes, my lord. Asking for a Passover.
This is now Cognizance has taken 2020. Now they are come up in 2024 to challenge the same. Let them go and appear at the time of framing of charge.
She can't say that.
And otherwise, the lordship fix a date in the other date.
On behalf of opposite party number 2 and that is going to serve. So release the matter on 28th of 29th.
This one, my lord. 29th?
29th.
63. I am appearing for the opposite party.
Yes.
I am also appearing for the petitioners today.
Yes.
I'll leave it to my learned senior will have the right of audience.
No, you are the petitioner. Why should I step into that?
Yes.
My most humble and most respectful submission, my lord. The lordship kindly come to page 59.
Page 59.
59.
Yes.
This is the statement of Rashmi Ranjan Sethi. This is recorded in the protest petition.
Okay.
Now, if I was lodged, the report was filed, the closure report, final form was filed, and the SCSP Act is not made out. And then against it, they filed a protest petition saying that no, there has been a slur against my name. And this is the statement recorded. These are a director.
202 statement. Yes.
202.
Yes.
The relevant portion is the 15th line to 16th line. Chinmay Das also raises issues concerning my competency and uses abusive languages against me, like I do not have knowledge regarding administrative work. He also said, by taking my surname, Mr. Sethi does not know ABCD of administration. This type of language has been used against me by Dr. Chinmay Das on several occasions.
The informant is also in doctor?
No, he's not a doctor. There has been a fracas. This man is a neurosurgeon. Man is a very effective and efficient neurosurgeon. Man, in course of daily duties, there has been a fracas. There may be a misunderstanding. Every misunderstanding and fracas need not snowball into a criminal case, and much less the SC/ST Act, where bail is also becomes a.
What are you seeking here? Quashing up for
I'm seeking quashing of that. Cognizance.
Why can't it be settled? Because you people are the highly placed doctors and all. What is this? Why
We are
don't
willing to settle, my lord.
Sir is there, then I think,
Let my lord.
and your presence is enough.
Your lordship will kindly see. He is a doctor, he is a faculty member. He has got nothing to do with the administration. I would so.
Merit, you may have a case. What I'm suggesting is, she is a doctor and she highly placed people represented by such a senior lawyers here. Why can't we settle
Let
it?
him approach and tender and a public apology will accept.
Public, I'll take instructions.
You file an affidavit here, I'll accept it and finish it up. Apology, I'll take it and see, you are a doctor, your concentration should be there in the hospital, not here.
I will demonstrate from the deposition, Lord, that but your lordship has held.
So we will go into the merits subsequently. Let us try to solve it here. Shall I send it to the mediation center and you give an apology and finish it up? Why unnecessary?
This is not the first time he has been doing this repeatedly, time and again. And
let him file an affidavit. You file an affidavit.
Next week we have filed the criminal case. It is no pleasure to go for a criminal case.
So let us put a rest to it. You file an affidavit. I am just simply adjourning it. 17th, you come with an affidavit. I'll accept
17th.
it. Yes, 17th.
17, my lord. Lordship, take it somewhere around 22nd, 23rd.
Okay,
21st,
20.
21st.
You come with an affidavit.
21st, 20, I'll come with an affidavit.
Tendering an apology. And I accept it and persuade
we will.
his client to.
So take instruction.
Let him file an affidavit here. What apology? Apology before High Court by way of an affidavit. What else you need?
Because he has been repeatedly doing it. He has been making complaints against me to my higher authority.
That also you write a sentence that in future also will not do it. Finish that.
But he is no secretary. That association is not recognized.
Right. The affidavit, please write that in the future also you will maintain sanity in the workplace. Maintain sanity in the workplace. That's all. You do it.
He's a doctor,
better was to do.
Conducts operation without admitting the patients, and he's a famous neurosurgeon. Less talked about it, it's better.
It's all right. File an affidavit.
Giant issues.
File an affidavit
Interim order
and interim order will continue. Please file affidavit and say, undertaking that you will not indulge in all this in future. Okay. 22 तारीख. Interim order to continue. Yes. And circulate the affidavit to his client. Yes.
Well,
64.
My lord, the dispute is arising out of the inter se parties. Previously, your lordship heard this matter. There are as many as 5 cases pending against each other, my lord. The dispute between two families.
Settlement.
Your lordship.
You said settlement.
I said, I said the opposite parties appeared. Whether
anybody appeared?
Not he entered appearance. He entered appearance. But
Mr.
no.
Samantra had entered appearance.
Entered appearance.
You speak to him.
Well, your lordship may kindly direct.
It.
My lord,
to the other side counsel who has entered appearance and try to work out.
Your lordship, I have.
Otherwise, I'll enter into the merits. If you can't work it. Okay. So and so entered appearance for opposite party number 2. Mr. Saul and counsel for the petitioner reiterate his stand that dispute being inter se party, there is a scope of settlement. He submits that he would be contacting the other side counsel and try to settle the dispute between the parties and to try to mediate for settlement. Please remember. Which interim order? Yes. Yes.
65.
Yes, madam.
Which case your lordship of innocent of time to entertain this application. However, my lord, ultimately lordship was pleased to issue notice. Here is the case where there is a fraud of 35 plans. In petitioner before the lordship, my lord, they are one husband and wife. Husband is a doctor, and wife is the owner of the nursing home.
Yes.
They need some money.
Instruction in this case.
The informant you have not implemented.
Implement I have not made because I have not added as an accused till date. My lord harassing me every day, calling me and pressing me to deposit to give the amount.
You are not made accused, why unnecessary?
ସେଇଟା ସେ ଡାକୁଛନ୍ତି ମତେ ବାରମ୍ବାର ଡାକିକି ପ୍ରେସ୍ କରୁଛନ୍ତି to pay the amount. That's
Now
why-
you have filed this petition, they will make you accused.
Last occasion also your lordship has filed that. But what is the instruction, my lord?
Lordship, it has the confidential piece of information that has been provided since the investigation is at a very nascent stage.
Yes, I understand.
Yes, Lord.
I am not passing you any information.
No.
What is the name? Name of the petitioner, Ajay Narayan and
They both are.
Sahara Nursing Home. There's something against you, or let it be. I'll just adjourn it. I'll just adjourn it. There are something. There's some evidence. There are some transactions to your bank.
My lord, I am ready and willing.
They have not made accused. They may make you witness also. We don't know. I don't know that I can't advise them. Because see, the money, the fraudulent amount is transacted to your account.
Say transacted amount.
From some Sumitra Khuntia to it gone to you.
The transacted amount of the because I am a doctor.
But I can't quash it, no?
Who am I passing yesterday?
Then?
Coercive action I am ready and willing to give the amount.
Lordship, the prayer portion is also seen in the CRJC.
No. Just show me. The one which you have shown me. I'll tell you the amount. What so far they have been with you. Against you.
Upon this amount, there is interest also.
Interest or interest. So far, 38 lakhs. So far, investigation. I don't know. Deposit 40 lakhs. Deposit 40 lakhs, I'll protect you. Seek instruction. Keep it 38 lakhs now, so far it is revealed. Deposit 40 lakhs, I'll protect you. Ultimately, he's interested in their money only, 2 point some crores. 40 crores has 38 crores has 38 lakhs has come. 38 lakhs has come to your account. You deposit, ensure that so that I can protect and investigation can go on. That can be done. That can be done. Think over. I let him later seek instruction.
I would like to take instruction.
You see. propose is, so far you have unearthed that about 38 lakhs rupees has been transacted to her client's account.
Okay.
So you will deposit that and you carry on investigation. Carry on investigation. Hmm.
I will take instruction.
Yes.
The movement of principal accused was that dhara.
I know.
After that, investigation.
Yes. We are not. I'm not saying anything that you carry on. If you want to make him accused, make him accused. It's a money transaction thing.
Yes, sir.
Nothing to cheating and all. Nothing has happened. Main accused has done. These people, the informant doesn't know also.
But as per the telephone information that I received, there are other nitty-gritties that involved.
You investigate. See, there is no direct allegation against these accused persons by the complainant.
Yes, sir.
Complainant has no privy with these people. Jininanti. Somehow the main accused has taken the money, transacted to their account. Whatever transaction has you have honored, that money he will secure and investigate. You want to make him accused or witness, whatever you want to do.
The account from which the money has been dispersed out. It's a closely.
I know that.
Yes, sir. Yes,
I know that.
I did not say
Yes.
I will take
Nobody will stand in your way for investigation or anything. And only protection. Ultimately, they are doctors. So that is the reason. Yes. Okay, I'll put it on 17th. 17th you come. 17th. Yes.
In the meantime, I will say, arrest
No, tell him not to precipitate. Yes. So give instruction. Huh? Don't do. Yes.
66.
Ultimately, the complainant is also interested in the money. At least 38 lakhs is recovered. Comes to come. Baki मिलियो कि नहीं भगवान जानती. ये दवा को राज्य उससे नहीं जाती मिलो कम से. ना तो किसी मिलियो नहीं complainant को. Complainant is also not interested in sending them to jail. किसी मिलियो नहीं. The every दवा को राज्य उससे arrest करी सती भी देखो. Because I'll take the bail. I'll face it. Better you take the money. Better. Yes.
My lord, item 66. Kindly may pass over, my lord.
Pass over.
Yes. Obligement.
67.
Press one. Press one.
The case, let's say this is confiscation proceeding.
Okay. Mr. Das appearing for the vigilance, submit that the matter be issued for hearing. 31st, interim order.
Let's say interim order.
Interim order.
Let's say I may suggest both the appeal, the conviction appeal is there. Both have.
That we'll see. This is something different. Yes.
68.
Lord, sir, let it be pass over for the day. Take some time. Petitioner counsel is not there.
It needs hearing.
It needs a lengthy hearing, my lords.
Lengthy hearing.
I'm appearing for 68, my lord. I'm appearing.
Yes, madam.
I'm appearing for item number 68, my lord.
Yes. For petitioner.
For petitioner, my lord.
Yes. Yes.
My lord, I am challenging the annexure 6, that is the impugned order, my lord. Case in short is that there had previously in 2010 there had been a CRLMC number 903 of 2009.
It needs hearing. It seems it needs hearing.
Needs hearing.
I'll put it for hearing sometime. Huh?
Not many times if I request to hear it today.
Let's see how can we adjust it. Yes.
69.
My lordship, on behalf of Mr. Gopal Agrawal, I kindly seek for a short adjournment.
Okay. On request, adjourn. Yes.
No, short term, fixed. One in the meantime, elapsed. Charge has been framed, so I'm worried.
No, charge has already been framed. Oh, there is no interim order. The consequence will follow. No, why do
No interim pass. So some protection will be given. Then take time to do an objection. Some interim order may be there, my less.
No, the first day I have not given interim order.
No,
means it
notice
needs
was
here.
issued on 23 to
I'll give a short date. I'll give a short date.
Next week.
Keep it on the 29, 30, 29, 30, 30, 30th. Okay. Yes.
70. Sir, in the meantime, the trial will start, sir. That is the problem, sir.
Yeah, we start.
So that I am, sir, anxious for to hear that matter. Can I
He is
already
asking
1 year
that-
past, sir.
Sir, my lordship, short adjournment any day next.
You are appearing for whom?
Mr. Gopal Agrawal, Enforcement Directorate.
Enforcement. देखो short date.
Sir, short
We'll
date
we'll
is-
try and adjust. Wait, huh? We'll try to adjust in the week, the next week. Next week not possible. 24th, huh?
24th.
Forward is 21, sir.
24th. Before that, not possible at all.
28th, 20th.
20th may not be possible.
Yes.
I'll list it, but hearing, I don't know whether it will.
17th.
24 रखो 24 yes.
24
24
What first inconvenience? Delhi goes
27 yes
22nd.
27 yes next
Obliged.
70. I love item 70. I am for this business. And in this case, I was noting is proposed not prepared. The applicant comes is not there also. And let it after preparation of
Wait. I'll edit in the weekly read correct weekly yes which one
Item 51, it is government has sought for instruction regarding service of notice.
wherever there is interim order that will continue wherever there is interim order yes Mr. Mohanty 40
item 70 was there, lordship.
Huh?
Lordship.
Which one 70
Lordship.
Adjournment.
I'm sorry, lordship.
nobody want
No, lordship.
you tell me what you want you said you came running then you must be wanting something
I'm sorry.
Huh?
Take
Take breathe. I have added it to the hearing list. If you want anything, you tell me.
Yes. I will mention.
And tell him
Yes.
if
I will mention. Let's put it.
Item 40.
14 May, please. Unless matter has been amicably settled between the parties, unless both the parties are present, my lord, I'm filing joint affidavit.
My lord, I'm appearing on behalf of informant, my lords.
what are the offences?
My lord, offences are 290.
What are the allegation?
My lord, the allegation was the petitioner and his sisters and other relatives have sold a land, and the petitioner was the mediator. Petitioner took 12 lakhs, and when they asked for refunding the 12 lakhs, he did not refund it. Then they lost the affair. But in the meantime, my lord, he has already paid the 12 lakh rupees. Both are present, my lord.
How many accused are there?
My lord, only one.
Yes. Investigation is still going on.
My lord.
And he was a mediator
My lord.
between the informant and the landowners.
My lord.
Isn't it?
My lord.
He has taken the money.
My lord.
Now he is. Who is appearing for
My lord, I'm
party? Yes.
I'm appearing on behalf of open number 2.
Purushottam Reddy.
My lord.
Purushottam Reddy कौन हला?
नाम दूसरे पसंद किए पैसा
खरीदिला କେତେ ଲକ୍ଷ ଟଙ୍କା?
12 लाख में
12 ଲକ୍ଷ ଟଙ୍କା ଆଉ ଜମି ଆଉ କିଣିବନି
ନାଇଁ
ଆଉ ଯୋଉ ଏଗ୍ରିମେଣ୍ଟ ଯୋଉ କରିଥିଲ ସେଇଟା
କରିଥିଲେ ସେ ବୁଝାମଣା ହଉଥିଲେ
Is there any specific performance suit filed?
No, my lords, nothing else.
Ah, right off. That is instance of opposite party number 2. Who is
No, good
ready?
Good.
Huh?
No, only one account.
Investigation is still going on.
My lords, the same.
Opposite party number 2, FIR number so and so claim to be registered against the petitioner for alleged commission of offences punishable under section 294, 323, 34, 441, 341, and 420 IPC. On IPC. The allegation against the petitioner is so. The investigation in the present case is still going on.
Okay.
At this stage, the parties have settled the issue. The the petitioner has funded the 12 lakh rupees, which has been taken by him as a mediator for the sale and purchase of land. But the parties have filed. What is this? Joint affidavit, huh?
My lord.
The parties have filed a joint affidavit before this
Fourth commissioner.
court on dated 10/1/2025 in Trilia stating as under 2, 3,
The prominent identified.
2 to 5.
2 to 5.
2 to 5. On the basis of the settlement term, the parties conjointly pray for the questionment of the FIR mentioned referred to above. The petitioner and opposite party are present in the court, being represented by their respective counsel and identified by them. They have also filed self-attested copies of their Aadhaar card, which are placed on record to establish their identity. Regarding to the terms of settlement, Mr. UC Jana is appearing for the state and submits that the dispute is inter-se parties, and the disputed amount of 12 lakhs has already been paid by the petitioner to the opposite party number 2. In that regard, the affidavit has been filed by the opposite party number 2, the opposite party public informant before this court. So investigation is still going on. Therefore, there is no legal impediment in pursuing the entire criminal prosecution initiated by the opposite party against the petitioner. Regarding head to the aforementioned, the petition deserves merit, particularly in view of the affidavit filed by the parties, joint affidavit filed by the parties before this court. Therefore, subjecting the petitioner to the criminal prosecution would destined to be a futile exercise. Hence, futile exercise. Hence, the case of the petitioner is covered by the Gansing so and so. Accordingly, is cost. Yes.
60.
60. Yes.
There is a case arising out of 130 NI Act Metal Lordship. And petition for recall of the period 1 for further consideration is rejected, Your Lordship. But in the petition,
they have not filed additional document.
Your Lordship?
Additional document is not filed. The matter is arising out of a complaint under section 138 NI Act. Petitioner is the accused in the ICC case number. ICC case number?
Yes, Your Lordship. Lordship 6151 of 2016.
61 ICC no 6151 of 2016.
That's it.
2016. No. 1 minute.
There is no petition under section 311.
The matter was taken up for hearing on 3/1/2025. Land counsel for the petitioner sought time to file additional document to substantiate his case. However, no additional document has been filed as yet. When the matter was called up for today on the second call, even on the second call, none appeared for the petitioner. Hence, the petitioner is dismissed. Yes.
18.
My lord, on behalf of
Yes.
Missy, kindly return to next week. Kindly return to next week.
Adjournment.
Thank you.
38.
Your Lordship, in 38,
May I please
last time, Your Lordship directed to file an affidavit regarding the antecedent part, Your Lordship. And the matter was stayed in 1/2024 for place to adjourn matter. But not only that was 24 has been mentioned, that modification has been filed in IA. But the said affidavit is not served by the Land Council upon the petitioner to us, Your Lordship. Regarding
Copy of the affidavit.
I have filed that affidavit that is mentioned on the column affidavit filed by the council.
You have to give the copy to him to verify.
It is already on the before the Land and Standing Council, Lordship. That is marked as A2.
Mark is 82 in the brief. In the brief, might have not supplied to the appearing.
In the court file, it is there, but it's not supplied to Land Council for the petition. Copy of affidavit filed
And the mail, email ID, and the
his behalf, on behalf of the petitioner to the Land Council for the state. Let him do so within a week, least the matter after. Yes.
Lordship, on the next week, it is possible to reinstate.
Yes, yes.
Yes. 6.
So that matter, my lords, the Secretary Bhubaneswar Development Authority, my lords, facing the protest petition, my lords, concerning my lord, demolition. That was there, my lords. My lords was about to pass the interim order, but my learned friend appeared on behalf of the informant.
Yes.
Because in this matter, cognizance has been taken. Process has been issued. And after getting summons, the accused through his lawyer must appear before the land court below and file an application for under section 205 CLPC to get his personal attendance dispensed with. And again, they're taking time there before the land court below. And here they have filed this application to get the proceeding stayed. You have initiated an action by filing an application.
Not say for quashing.
Quashing, that you also have been pleased to issue notice. But now it is only for the purpose of whether stay should be granted in that proceeding or not. So they have initiated action there before the land court below by filing a 205 petition. There no order has been passed.
No. Stay forget about quashing. You just
quashing on merit was submit.
Yes, merit.
May I submit?
Yes.
Thing is that, my lords, the process, my lords, I am now compelled to face that trial, my lords, 221 CC case, my lords. But is that basing upon the protest petition. My humble concern is not maintainable. Now, my lords, I will be I'm presently a collector in the district. I have to face the proceeding because of
that 205 application is allowed.
No, but that has not been allowed. That is pending. But pending of that we have come before the Honorable High Court.
Yesterday they have taken time.
What are you seeking time?
No, my learned friend has taken time because my lord for the passing to stay the interim that proceeding.
No, I
appeared. You just simply tell me whether you are raising this petition for quashing.
Yes.
Or 205. 205, then I'll
205 more seats. I am not.
Then your prayer is for quashing.
Quashing.
Let us concentrate there.
We will quash it, but that is there my prayer. My interim prayer is the proceeding was so far that once is a case, panel is to be stayed. But fact can visualize one thing. What has happened in this case? First, my lords, I am the secretary. Well, thing is that,
if I am satisfied on merits of the present case, then only the question of say arises.
But that is exactly my
Cognizance Order is passed.
I'm pointing out a prima facie case for minor satisfaction, prima facie satisfaction.
Yes.
Well, kind of a class one one. That is what minors after going through only made of mind to stay.
Yes.
Kind of a class annexure 1 minor. At page 26 minors, how they proceeded. 27 minors.
Yes.
Minors, it starts order dated 20th 9 2024.
Yes.
I'm reading minors the relevant portion.
There is the complaint.
Initial statement of the complainant and the statement of witness under 202 CRPC. It appears that the accused persons are not public servant. That is very important. The learned court proceeded on that premises. And the time the initial statement has also been mentioned that the accused persons are public servant, not mentioned public servant. So now thing is that whether
the initial statement of the complaint has also not mentioned
that the accused persons are public servant. I'm not going to all the details, minors. I'm pointing out only one point. So think is that I'm a public servant or not. If I am a public servant, my first attack is 197 is very much attracted. In absence of that, the proceeding cannot commence. So to that extent, my lords, I pray my lords, my kind of glass to section 99 of Odisha Development Authority Act. 99 and not that. But my lords, prima facie satisfaction. Then I will point out the case is not better. I was not there. And think is that my lords knows that it is an eviction process. Now think would be that my lords, any officer will go and undertake eviction. Of course, I was not there. My lords, eviction team was there, and they will go on evicting my lords. Then they will be subject to
Of course, I can show that he was very well present.
No, that's a different story. But whether they are public servant or not.
Plus, there.
The court goes with a assumption that they are not public servant. All of them are.
Plus, initial statement has not been provided to the Hon'Ble court.
No, yes, that
This is a finding.
I'm enforced.
This is a finding in a cognizance order saying that they are not public servant.
Plus, public servant court has, but court it is.
See, it says that. It appears that the accused persons are not public servant. On that presumption, it goes. All of them are public servant.
You also can see
the provision manners, specific provision manners.
Yes. 99.
99 manners. Then 100, 99 on 100. It's not that I am doing for my purpose. All that I am doing manners. But considering for the sake of argument, I was there.
Yes,
one document has been suppressed, that is the initial statement recorded in 200 CRPC. That has been suppressed, that has not been given. And then was government.
That initial statement, I have given all this.
You have made a statement.
I have given all this.
You have got
page 27
of the petition. Last part of paragraph 9. The records reveal that the informant didn't examine herself as required under 200 and 200 CRPC.
Yes.
On 200, she has been examined, and this document has not been given.
No,
the laws may kindly see what
that is what
statement
I applied for.
Just a minute, let me whatever given by the complainant.
Let me finish. Let me
statement record.
I request my friend, man. Let me finish that so that you can. Contingency will be, my lords. All these officers discharging public function, my lords, evicting, protecting government land, protecting unauthorized construction, and you filed that was not very important. Now everybody will suffer. In CDA also now.
That is your case. No, do you have 202 statement?
Yes, 202 statement, my lords. It is annexed to page 26. Whatever that has been supplied to me. That I will enforce that certificate copy.
Yes.
That is there. Once
page 28. She has not 28.
Yes.
Next page, notes. Because initial statement has not been given. Initial statement has not been given.
No, did it? One case deposition, pa?
No, I don't know. Initial 200 service statement of the lecture
202.
200 service.
200 to kichachi ke ram to 202 ran choti ki.
That's the statement. 20.
No, 200 service. 200
is the complaint under the complaint.
No, 200 service that is statement.
No.
I'm showing a lot.
200 plus 200. 200 to
that is initial statement.
The copy to the that too, my lord, here in this case, police investigated into, in presence of police, all these actions have taken place. My lord, the demolition and everything.
So from the document,
my lord, the police has investigated into and submitted a final report false. And basing upon that, my lords, now my lords, prosecution filed.
Specific only one word.
But if that will be so, my lord, the contingency will be so, and no statutory function can be discharged. All officers will be put into trouble. And my lords, suppose my lords, it will not be started, I will be facing that trial then. And the proceeding will continue on that basis.
Your old lady only behind you.
What is your case, my lord? So what is their case? My lord, may I read it? That would myself submit a few lines, my lord.
They were doing their official duty.
Yes, they were doing their official duty.
Plus, you also can page 28.
Yes.
You are taking a view, page 28. Paragraph 3. Witness. The plot is a corner plot.
Yes.
And has road on the north and east side. the complainant has deposited 20% more of the actual rate of the plot.
That is on merit.
My humble contention, all these minors may entail a right in your favor to carve out remedy. You have carved out that remedy.
So what?
Where there was Honorable High Court directed to deal with the secretary, the present petitioner being secretary dealt with that, rejected and invited this.
I'm getting 2 ingress roads. What made you? Even if you are doing, you are.
If I'm telling somebody.
You get somebody. What made you to construct a wall?
But just a minute, please.
On the ingress road.
Yes, it is not your ingress road.
Yes.
It is a part of the marriage.
20% extra for that.
And then also this should be a case, my lords. You can carve out remedy before the civil court. It is civil dispute. You are just giving a.
This is a senior lady. In what way she has been treated?
And that is not
But
that. I will say.
You are showing your position. You are not. I mean the lady, elderly lady. What is his social position? You should understand also.
One.
No. You from the statement under 202 and initial statement.
Yes,
you tell me who has done what.
Here.
Well, so these part.
1 minute. Who has done what? There are 4 accused.
Yes, here one accused has come up.
Then you just tell me what is the role attributable.
On 15/11/2022, some employees of BDA.
Kavinendra Kumar Sahu.
Yes.
Kavinendra Kumar Sahu. What are the allegations?
Yes.
From the complaint, from the initial statement and 202 statement, you tell me what this man has done.
Because all the 4 names have been taken.
Yes. All these may be checked up.
You have implicated 4 people.
He was very well present.
No, wait, tell me from the statement where is what is.
Come to.
I have read all everything.
Page 58. Yes.
You simply say what he has done.
Yes.
As simple as that.
The accused person plus paragraph 6. First paragraph 4. On 14/11/2022, some employees of BDA and other persons came and closed the north side road of the plot by constructing a boundary wall. Again, they came on 5/12/2022. The accused persons again came and increased the height of the boundary wall. I was in the office and at about 2 p.m. Then I am coming across 3 lines bottom. She further stated that when she obstructed them, the accused person pushed.
You obstructed.
Who is that accused person who done what?
4 persons are accused persons.
You who knows better than you? Unless some specific allegations are made against it.
Plus, names have been specified.
I don't know officers whether these officers are there or not.
No, they are there.
You show me in the entire complaint, preliminary statement, initial statement, and 202. Pick the name of any accused.
These persons are present.
I don't know. They will say that we were not there. Some other officers were gone. How do I know?
Their documents have been annexed.
No. You from the complaint, from the initial statement. From the 202 statement, you tell me what have the complainant has taken the name. This man has done this. That man has done this.
No, yes.
Official. What official? 1,000 officials are there. Stay the proceeding. Stay the proceeding argument. There is nothing.
Maybe hard gloves are the earliest.
That stay the trial court proceeding for the listener. See, this is very difficult for you.
May
you not taken the name of any accused? Officials, who is the official?
That is exactly.
Then simply say that we are not there. You show me one name. Forget about his name anywhere in the entire complaint, initial statement.
Complaint
ना देखो
specific attribute
ना देखा तू ये इटा कल्ला मरला 354 ब्लाउज फाड़ दला की फाड़ लगा ब्लाउज
आपण गले धमकी की सेठी एनफोर्समेंट अफसर पहले पुलिस अछंती लेडी पुलिस अछंती
समस्त अछंती ब्लाउज फाड़ दला की फाड़ला
and what most unfortunate part is that
and these two officers one of them is collector ब्लाउज फाड़ला
ब्लाउज में खाली सी तो paragraph 1 the biodata given by the official.
Those who
the biodata also can see.
You have a tough time. And he knows it.
My brother knows better than
anyone else. That is the problem. Yes, we'll hear it. Okay, stay. He's already. Mr. Kotika is already there. Argument part heard, and we'll see matter for further hearing. In the meantime, the proceeding before so and so.
Urgent coffee.
Okay, thank you.